Good evening. I will now call the March 6, 2023 council meeting to order at 6 p.m. as per the town bells. I understand we have a number of people here for a number of issues, and I'll ask for patience as we try to be as efficient as possible to make sure that when we get to those. My understanding is that Councillor Van Koonbos says you have a motion.
I do, Mayor Petrie, thank you. Moved by myself and seconded by Councillor Hudson that we consider items 11 through 17 on the agenda after we hear the zoning applications public meeting and our delegations and presentation on the agenda.
Excellent. Is there any discussion on that motion?
I'm just doing this so that we can try to keep those that are here to present from having to wait until after all of our reports. I like all of you. I don't think that you should have to wait until the very end to come up and speak to us in that respect. So that's why I'm asking for that.
Excellent. Thank you very much. Any further discussion? All those in favor? Opposed? That is carried. We'll make the change in that, and then we'll move on to disclosure of pecuniary interest, please. Any disclosure of pecuniary interest? Seeing none, we will now move into delegations and presentations at 6 p.m. Mr. Graves, would you like to introduce our presenter, please?
Yes, thank you. I am very pleased to introduce Cody Groat, who is an assistant professor with the History and Indigenous Studies Department at the University of Western and also an Ingersoll resident. Cody has graciously agreed to be here today to share a presentation regarding the Truth and Reconciliation, addressing the call to action number 57. Thank you, Cody, for being here.
Perfect. Thank you, everyone. I know I have a mic, but it's also a very small room and it's not a very big crowd, so hopefully everyone can hear me fine. It is great to be here today. This is my first council meeting that I've had the chance to attend here in Ingersoll, and it's a great opportunity to be able to present to the community. I would like to start by thanking Mayor Brian Petrie for inviting me to deliver this presentation before this council term started. I would also like to thank Chief Administrative Officer Michael Graves and Clerk Danielle Richard for meeting with me prior to this council session in 2022 to discuss the context of what we're going to be introducing today. I would like to thank Deputy Clerk Paula Toft for helping arrange this agenda. It's a very lengthy agenda, and we know that you put a lot of work into it, so thank you very much. And also, before I get going, I would like to take the time to recognize Patricia Marshall, who's here in the audience, as well as Giselle, Brenda, and Lisa, who have been coordinating the Ingersoll and Area Indigenous Solidarity and Awareness Network. And in my opinion, this organization has done more to advance the cause of truth and reconciliation than any other group or individual in our community in a very long time. So they deserve to be acknowledged, and I see they're very happy for that today. So anyway, I would like to start that because I think it's important for us to recognize we need to have change from the top down, from mayor and council, but also we need to support change from the bottom up, which is happening in our community. Only by doing that will we be able to actually act upon Call to Action 57 and the content of my discussion today. So for those of you who don't know me, I am an assistant professor in the Department of History and the Indigenous Studies program at Western University. I grew up here in Ingersoll in Adam Oliver Housing Cooperative and elsewhere in town. That's going to be integrated into my presentation as I often situate my own lived experiences with this important content. I am a band member of Six Nations of the Grand River. I'm from the Kanyen'kehaka or Mohawk Nation, and again, that informs a lot of my presentation today. So I'm going to explain what the calls to action of the Truth and Reconciliation Commission are later in this presentation, but first and foremost, I'm going to explain Call to Action 57 because that is why I'm here today. It says, we call upon federal, provincial, territorial, and municipal governments to provide education to public servants on the history of Indigenous peoples, including the history and the legacy of the residential school system, the United Nations Declaration on the Rights of Indigenous Peoples, treaties and Aboriginal rights, Indigenous law, Aboriginal Crown relations. This will require skills-based training in intercultural competency, conflict resolution, human rights, and anti-racism. So there's a lot to cover today in this agenda. Some of it is outlined in the next slide, but I'm going to quickly stay on this first call to action because I believe there's two parts to this presentation. In my opinion, I'm addressing the first half of this call to action, providing public education on residential schools, treaties, Indigenous nations. The other section of this call to action, skills-based training, intercultural competency. That is a certification that I do not offer, that I am not able to present. So in my opinion, after today, after this, Ingersoll Council has addressed the first part of Call to Action 57, with more work to be done afterwards. And again, I'll discuss that later in this presentation. It's also my belief that this call to action should not be a checkbox that is done once. It's my opinion that this should be done every cycle of council, likely or hopefully within the first few months of a new council term, to assure that it sets up the context for decisions that are made later on. So we have a lot to cover today. I feel just like I'm in my Indigenous Studies classroom earlier today. Our agenda is going to be pretty extensive. We're going to give a brief history of the Indigenous nations whose lands have been occupied by Ingersoll. And I'm very selective in that wording because these Indigenous nations are still extant. We are still here as our communities. Ingersoll is a municipality that we recognize, but again, it is over top of Indigenous nations and communities which are still here and vital and active. We're going to have a brief history of the treaty relationships associated with these lands, and I say brief for all of these things because I teach entire courses on these that last for a year, so we're going to fit them into a slide each. We're going to do a brief history of the Indian residential school system, a brief history of the Truth and Reconciliation Commission of Canada, brief history of the United Nations Declaration on the Rights of Indigenous Peoples, and potential next steps for Ingersoll Council based on the calls to action of the Truth and Reconciliation Commission. I will note that my conversation about the Indian residential school system includes personal content regarding my family's lived experiences, which I always integrate into these presentations. It also does mention instances of physical, psychological, cultural, and in some cases sexual abuse, because this is the reality of what happened to students who attended. So I will situate the stage in that regard. But first, we're going to talk about the Indigenous nations whose territories are now occupied by what we know as the municipality of Ingersoll. The first that I'm going to discuss is the Haudenosaunee Confederacy, which I am a part of. Now, some of you might know the Haudenosaunee Confederacy as the Iroquois or as the Six Nations. These are English terms that have been applied to our confederacy, which we recognize as Haudenosaunee. And again, Haudenosaunee Confederacy is a political union of 6 sovereign nations, 6 independent nations or countries, and that's why we get the term Six Nations. And these are the Seneca, Cayuga, Onondaga, Oneida, Mohawk, which I am a band member of, and Tuscarora. So when we're talking about this confederacy, we need to realize this is 6 distinct political countries that have unified as a collective, which is now recognized in English as Six Nations or the Iroquois. The traditional territory of the Haudenosaunee Confederacy includes New York State, is mostly where our homelands are situated, but we also have political jurisdiction throughout southwestern Ontario up towards Kingston Way through a diplomatic agreement with another confederacy, another group of Indigenous nations called the Anishinaabe, and I will discuss those diplomatic relations shortly. The largest federally recognized land base associated with the Haudenosaunee Confederacy is Six Nations of the Grand River Reserve, where I'm a band member of. And again, that wording is very specific, the largest federally recognized land base, because we recognize our land base as being this entire region. The Government of Canada recognizes a smaller portion, Six Nations of the Grand River Reserve. Locally, there's also Oneida of the Thames, who are again affiliated with the Haudenosaunee Confederacy. The Haudenosaunee Confederacy is governed through a hereditary council, and I'm going to explain that on the next slide. And that includes representation from all of these 6 sovereign nations. Now, as a municipal government, you will likely not have interacted with the Haudenosaunee Hereditary Council before. You would have worked with the elected Council of Six Nations of the Grand River, or the elected Council of Oneida on the Thames. And while that's important, we do need to recognize that there's also flaws associated with that, which we'll discuss shortly. So here I just have 2 maps of the 2 Haudenosaunee communities that I recognized. Six Nations of the Grand River Reserve, we can see here on the left. It is the orange segment of this large green tract of land. Now, this large green tract of land is called the Haldimand Tract. It was land granted to the Haudenosaunee Confederacy in the late 1700s. Settler communities have slowly occupied portions of this land grant, and our territories, our federally recognized territories, have shrunk over time. So our reserve land base is now this tiny orange segment outside of Brantford, but our federally recognized land grant used to include Kitchener, Waterloo, Cambridge, Guelph, this large tract of land here that we see, 7 kilometers on either side of the, or Yeah, I need to figure out my numbers. Anyway, a large tract of land here. This is currently being disputed before the Canadian court system, that this land has been illegally superseded by a few of these municipalities. The Government of Canada has said that if this lawsuit advances, it is quite likely that it would win in a jurisdictional system, and it could bankrupt the country because of how much of a land base has been illicitly taken. So this is being stalled in the Canadian court system because it is recognized that it is a valid case that our land base has shrunk illegally, and the financial implications cannot be handled currently by our federal government. We see here on the right as well a map which identifies where Oneida on the Thames is located on the other side of London. And again, these maps are available in your slides. But there's the Haudenosaunee Confederacy, a collective of 6 sovereign Indigenous nations. We also have the Anishinaabeg or the Anishinaabe. This is a collective term, again, for a lot of Indigenous nations who form as a unified government or body. So the Anishinaabe include the Ojibwa, the Chippewa, or the Mississauga, Potawatomi, Algonquin. You might hear some of these terms. These are all independent, sovereign nations that fit under this same umbrella. Federally recognized land bases associated with the Anishinaabe close to us include Chippewa of the Thames First Nation or Mississaugas of the Credit First Nation. And these are all Indigenous communities who Ingersoll might interact with as it delivers its responsibilities. Traditionally, Anishinaabe governance has been governed by 2 types of council. There's a common council, which was concerned with specific issues regarding a particular territory, so internal issues essentially, and a general council. A general council was responsible for renewing alliances with other nations, including the English or the French or the Canadians, and affirming territorial boundaries through treaties or other agreements. These are again maps of Chippewa of the Thames, which you can see on the left, Chippewa of the Thames First Nation just outside of London, and Mississaugas of the Credit First Nation just outside of Brantford, close to 6 nations of the Grand River Reserve. So the Haudenosaunee Confederacy, which I'm part of, are 6 nations, and the Anishinaabe shared political jurisdiction over the lands of southwestern Ontario, so where Ingersoll is located today. And we have this shared jurisdiction through this diplomatic agreement that we see here, through this treaty, which is called the Dish with One Spoon Wampum, is what we refer to it in as English. The Dish with One Spoon is a diplomatic agreement. It's an international treaty between 2 political bodies, the Haudenosaunee Confederacy and the Anishinaabe. This agreement is also with the natural environment. The natural environment is part of this agreement. We recognize the natural environment as a sentient being, and it is part of this diplomatic agreement. This has been in place since before the arrival of Europeans, and it is still a diplomatic and international agreement that is in place today, which governs political relations in southwestern Ontario. This acknowledges that both the Anishinaabe and the Haudenosaunee were eating out of the same dish, essentially. That's why we have this name for it. We are using the territory of southwestern Ontario, 2 distinct political entities. We both rely on the ecological well-being, the ecological health of this territory, so we're going to respect that in how we engage in our political relations with one another. And that is why two sovereign groups, 2 sovereign nations can collectively use this shared tract of land. My colleague Leanne Simpson is quoted here, "Our ancestors intended for this relationship to continue perpetually. It is highly relevant in contemporary times because it sets forth the terms for taking care of a shared territory while maintaining separate, independent, sovereign nations." So again, Canadian governments, municipalities such as Ingersoll occupy the lands that are represented through this treaty, southwestern Ontario. There is a willingness, historically we've seen by the Haudenosaunee Confederacy, by the Anishinaabe, to integrate other nations into this, integrate the government of Canada, so that we can operate as the Haudenosaunee as independent sovereign peoples, Anishinaabe can operate as independent sovereign peoples, Canada can operate as an independent sovereign nation. Our political jurisdictions would not interfere with each other while still using the same tracts of land. That has not been the case of how Canada's governed itself, as we'll see, but I'll touch on that a bit more later. As I mentioned, the Haudenosaunee Confederacy has a hereditary government. This governance system has been in place since approximately the year 1100, 1142 is when this was instigated. And the hereditary government is still in place. It's one of the longest democratic governments that we have in the world that we know of. But the Indian Act, which is still in place as a piece of federal legislation, abolished the hereditary government. So the Indian Act was passed in 1876 to consolidate previous legislation regarding the administration of Indigenous peoples. And I'm very selective with that word administration because that is the tone that is set when talking about the Government of Canada and Indigenous peoples. The Indian Act established elected councils, which is what Ingersoll Council would likely interact with. And when I talk about administer, I think of the Indian status card that I have in my pocket, which legally states that Cody Groat is a status Indian per a specific section of the Indian Act. So it defines my identity based on the stipulations of this Canadian piece of identity, or a piece of legislation. Now, my colleague Cora Voyager is quoted on the slide, and it says, she says, in some ways, an elected chief is like the mayor of a small town, dealing with social issues and the local economy. Now, it's important to recognize someone like Chief Mark Hill, Six Nations of the Grand River. He's the elected chief, and again, his position is very similar administratively to a mayor of a small municipality. But this is very problematic. As the slide says, this has shifted the role of Indigenous governance, how we govern ourselves, from that as sovereign, independent political nations to that of a regional political figure. So the Indian Act has tried to downgrade how we govern ourselves and how we perceive ourselves as nations. This has often individualized leadership, where before it was a collective governance model, now it is very individualized, and it's often made it patriarchal. For the most part, elected chiefs and councils have been men. The Hereditary Council of the Haudenosaunee Confederacy, so the governance body that governs the nation that I'm from, has actively contested this idea that the Government of Canada supersedes our sovereignty, that they are now the political nation who oversees us as a people. We have never forfeited our sovereignty as a political people. In 1924, as the Haudenosaunee Confederacy was actively contesting these claims that Canada supersedes us, an order in council was passed by the federal government to formally disband the Hereditary Council. So in 1924, 99 years ago, the RCMP came onto our territory, the Hereditary Council was forcibly disposed, and an elected council was voted in the next day. And that elected council is still in place today, and if Ingersoll as a municipality is consulting with legislative or with elected chiefs and councils, it will be this body that's been imposed by the Government of Canada. So the province of Ontario and the Government of Canada has a legal duty to consult with Indigenous peoples regarding legislation that might impact our rights through Section 35 of the Constitution, which guarantees First Nations, Inuit, and Métis rights. But again, this consultation always takes place with elected chiefs and council. So while it's a very important step, and I'm not downplaying it, we need to recognize that the political bodies that Ingersoll Council will be dealing with are also bodies that have been imposed and do not necessarily reflect the realities of Indigenous governance, which still exists today. And some of this governance is influenced by the Upper Canadian land surrenders. Now, the Government of Canada does not formally recognize treaties in southwestern Ontario. They refer to these as the Upper Canadian land surrenders. And the reason why they choose that term, calling them Upper Canadian land surrenders instead of treaties, is that the federal government has argued these were more of transactional agreements instead of diplomatic. This was a purchase of land instead of an agreement with an internationally recognized nation. But again, Indigenous peoples, including the Haudenosaunee, actively contest this interpretation. And that's partially because the concepts of private property, of land ownership, permanently transferring our responsibilities associated with a territory, these are not terms that are translatable within the ways that we govern ourselves. As Haudenosaunee, or as my neighbors, the Anishinaabe, this idea of permanently surrendering our rights to land is not politically or culturally transferable in our mindset. I'm going to talk, though, about the two agreements that did cede the territory that represents Ingersoll. So Ingersoll is represented through two separate treaties, and the Thames River is the dividing line between these two treaties. So south of the Thames River is Between the Lakes Treaty number 3. This was negotiated in 1792. This is an agreement which is still in place to this day. The Mississauga Nation entered this agreement, which transferred 3 million acres of land for 1,180 pounds worth of trade goods. And again, this land was then sold to white settlers or speculators for substantially more than that. You know, we can comment about inflation rates or the benefits of trade goods, but we clearly recognize that this was a deal that was not made in good faith. And again, the terms of the agreement are not translatable with our notions of governance. And I'll explain that on the next slide, but you can see here on this map, Treaty 3, 1792, you can see the territory that it covers, includes the south side of Ingersoll, all the way down to Lake Erie, up towards the other side of Kitchener-Waterloo. We also have the London Township Treaty. The London Township Treaty covers the north side of the Thames River in Ingersoll. The Chippewa Nation entered into this agreement, which transferred 7,660 acres of land for $1,200 in trade goods. You can also see it on this map here. It's a bright pink one near the word London. And again, one thing I'm going to point out before I move on, you can see that these treaties are signed, for instance, with the Mississauga Nation, or they're signed with the Chippewa Nation. As I've discussed in these presentations, there are several sovereign nations associated with these lands. So this is not a one-off deal. The government of Canada looks at these and says, we have signed treaties with Indigenous nations. This is a done deal. We have these in place. There was a lot of the Indigenous nations that had political jurisdiction. So when we see conflicting land claims, different discussions about this land being ceded, this land being unceded, this land being negotiated through treaty, this is where the complication comes from. The fact that there are several distinct nations that have political jurisdictions. Each of their claims were not negotiated. And again, these statements in these agreements are not translatable to our ways of knowing. I'm going to read an excerpt from the London Township Treaty, which represents the north side of the Thames River. This agreement states the following: the land is forever clean of and free from all claims, rights, privileges, emoluments which we, the Chippewa Nation, might have had before the execution of these presents, and free and clear of any pretend claim which our children or descendants may hereafter make, hereby renouncing and forever absolving ourselves, our children, our descendants of all title to the said parcel or tract of land. So again, it's a very transactional language. It's very blunt in what it's trying to claim, that the government of Canada now has full jurisdiction and full authority over this land. Descendants are not allowed to claim any ownership or stake in this land. I sound like a broken record, but culturally this does not relate with how we govern our territories. We also see this treaty even specifically states it's with the Chippewa Nation, several other Indigenous nations whose claims have not been absolved through this treaty. So it can be argued the north side of Ingersoll, of Thames River, is still the political jurisdiction of several nations. And again, this is a very tiny screenshot of this treaty. The treaty document is quite large. This is the bottom right-hand corner, and we see here the signatories of this document. And these are signed with dotums. Another word we might see is totem. That's a word in English that's more translatable. These are dotums inscribed on this document, and they stress the ecological responsibilities that the Anishinaabe felt they had with their traditional territories. These are all animals or species that are directly associated with these lands, and they're animals that we have direct responsibilities for. And again, this demonstrates how Anishinaabe society and forms of government are inseparable from the landscape. That's why we can't permanently sell a tract of land, because we understand that we govern ourselves as inherently connected with the ecological responsibilities that we have. We cannot permanently surrender our responsibilities to a landscape because it's not ours to surrender, and we also have responsibilities to the ecological species who reside there. So that's a very brief summary of Indigenous nations and on treaties, and we're going to move to the topic of residential schools. Again, this can be a very difficult subject, so I apologize if I take some delays. This man here, Nicholas Flood Davin, is a Canadian journalist. He was a Canadian journalist and later a member of Parliament. The Indian residential school, or system, was formally established in 1880 while Sir John A. Macdonald was serving as both the Prime Minister of Canada and the Superintendent General of Indian Affairs, so he had administrative authority over both. At Macdonald's request, this man, Nicholas Flood Davin, traveled to the United States and prepared a report that we call Report on Industrial Schools for Indians and Half-Breeds, and this was a very influential report in the history of our country. I'm going to read 3 quotes from this. written by Nicholas Flood Davin. The industrial school is the principal feature of a policy known as aggressive civilization. It is found that the day school did not work because the influence of the wigwam was stronger than the influence of the school. Industrial boarding schools were therefore established. The experience of the United States is the same as our own as far as the adult Indian is concerned. Little can be done with him. He can be taught to do a little farming and to dress in a more civilized manner, but that is all, and what he learns is soon forgotten. So we see the basis of the residential school being established through this report. The mindset is aggressive civilization, forced assimilation into a different culture. Nicholas Flood Davin recommended partnerships between the federal government and church denominations to oversee the daily operations. So churches would oversee the daily operations of a school, and the federal government would fund the schools. And this is rooted to the Canadian Constitution, the British North America Act. While provincial governments have jurisdiction over education in most cases, the federal government has jurisdiction over Indigenous peoples. So residential schools were therefore run by the federal government instead of the provincial government. And here are some of the recommendations we see in Davin's report. The importance of denominational schools at the outset for the Indians must be obvious. One of the earliest things an attempt to civilize them does is to take away their simple Indian mythology. So religious conversion was strictly embedded within the school system. Further, the federal government and religious denominations focused on agriculture and domestic service. Boys were trained in agriculture, girls in domestic service, so that, quote, the schools will be self-supporting in a few years. The idea was that if children were involved in agricultural labor and domestic service, they would bring in an income which would be able to put towards the operation of the school, lower expenditure for the federal government. So we started to see a transition away from actual educational provision, and instead we started to see manual labor being embedded in these schools. And often what we hear when we talk about systemic abuse in residential schools is that this is a topic that's just come up quite recently. But again, we have a long history of flagging the systemic abuse, mistreatment, and poor financial support for these schools for a long time. On the screen is Florence Nightingale, very famous British nurse and social reformer, statistician. And she wrote a report in 1863, before the residential school system was formally established, but while we still had residential schools in this country. Her report is called Sanitary Statistics, Native Colonial Schools and Hospitals. So she visited schools similar to this in Canada, the United States, South Africa, Australia, New Zealand, all across the British Empire. And Florence Nightingale said, the Indian schools in Canada afford a total annual death rate of 12.5 per 1,000 students, but the mortality of girls is nearly double that of boys. The death rates are, of course, only an approximation of the truth. And again, I've done the statistics to make them more translatable to us today. If we look at these same percentages, there's currently 75,000 students enrolled in the Thames Valley District School Board. This would mean that 938 students die every year because of the schools themselves, because of the conditions within the schools. 938 deaths a year because of the schools. The largest amount of work is given at the Canadian schools, says Florence Nightingale. Out of the whole number, there are only 9 schools in which any attempt is made at combining the elements of physical education or work with school instruction. So we see here already that physical or school instruction is not the priority within these institutions. A man named Dr. Peter Bryce, who's widely recognized, he was the chief medical inspector for the Department of Indian Affairs for the Government of Canada, also flagged a number of issues. He wrote a report in 1907 based on his tour of 35 residential schools. Bryce noted that upwards of 64% of students were dying as a result of poor ventilation or otherwise unsanitary conditions. So their deaths were directly associated with the condition of the schools. He noted that many students were also dying within 3 years of discharge. So when we talk about mortality within residential schools, we need to realize the lingering health effects also increased mortality rates of people after they left the schools, and we're not recognizing that as part of this overrepresentation of child deaths because of the residential school system. Peter Bryce leaked his report to journalists because the Department of Indian Affairs refused to publish it. He placed the blame directly on the federal government, and again, it's because of those jurisdictional issues. He said, in the public school system, the child returns to their parents at nighttime, and the parents are chiefly responsible for its health. On the other hand, residential schools are year-round, and for Indigenous children, their health is the immediate responsibility of the staff of the school. So again, the blame was placed directly on the federal government as early as 1907. Physical and sexual abuse were persistent. A student named Lorna, who attended the Mohawk Institute between 1940 and 1945, shared her story. And again, this is a graphic quote, but I think it's important. My brother was there too, and I'm thinking now, maybe that's why the boys wet their beds so much, because the men were sexually assaulting them. But the boys' dorm was just a big stench up there. Mattresses were rotting. And again, this is the school my grandparents went to. This has a direct impact on our community, as I will be discussing momentarily. We do not have a residential school within Ingersoll, within Oxford County, but there are two schools in which children from our communities did attend. The first is Mount Elgin Residential School. It is not in Mount Elgin, Ontario. It just has the same name. The Mount Elgin Industrial School opened in 1847 on the territory of Chippewa-the-Thames First Nation, just outside of London. It was run by the Wesleyan Methodist Church and later by the United Church Board of Home Missions. The land and the school were the property of the federal government, and again, it was the federal government who financially supported the institution, religious denominations who oversaw day-to-day operations. Bernice Jackson was a survivor of this school. She attended between 1939 and 1944, and she said, "We lost all of our Indian language and culture for being there. We weren't allowed to speak our own language. If they heard us talking in our language to someone, they'd tell us not to talk like that, and if we did anything that wasn't suitable to the staff, we would get strapped." And because of this mindset, because of these practices, the Government of Canada, the United Nations has recognized linguicide in Canada, the loss of Indigenous languages. In 2021, it was noted that 75% of all Indigenous languages in Canada are endangered. This means that there is a serious risk of their transmission, fluent transmission from one generation to the next. And we have census records of my grandparents. We have census records from when they were children. They were 4 and 5 years old. The census records indicate that they spoke Mohawk in their home as a first language. My grandparents both went to residential school. After that, they did not speak their languages anymore. They were not passed to my father. I do not speak Indigenous languages. And here we see the direct connection between the residential school system and the eradication of our culture. The other school that's immediately close to us is the Mohawk Institute Residential School, which is still standing today. This is where my grandparents were forced to attend. The Mohawk Institute opened in 1831, and the federal government was first financially involved in 1885. Prior to that, it was entirely run by the church. The school closed in 1970 in the lifetimes of a lot of people who are here. This was primarily operated by the Anglican Church, first through the Company for the Propagation of the Gospel in New England, and eventually through the Diocese of Huron of the Church in England, based in London, Ontario. In 1914, this is when my grandparents went to the Mohawk Institute. My grandfather was born in 1910, so he actually started going in 1918, so a bit after this. But still, 2 students charged the principal with cutting their hair, imprisonment, provision of bad food, and whipping. This is with a 9-pronged whip. This case was tried. The principal was criminally convicted. The charges of imprisonment in a cell and whipping were upheld by a court, and he was fined for his crimes. He remained as a principal, but again, 4 years later, he was the principal when my grandfather began attending the school. 1965, this is when my father was 15 years old. Had he not lived in our communities and in London, he would have been attending the school at this time. A former student criticized disgraceful food, beatings, and other punishments at the hand of staff. witnessing students having their face rubbed in human excrement and urine as a punishment for bedwetting. Again, this is another quote from the Truth and Reconciliation report directly. After a 1907 inspection of the Mohawk Institute in Brantford, the Ontario Inspector for Indian Agencies reported, "I cannot say that I am favorably impressed with the sight of 2 prison cells in the boys' playroom. I was informed, however, that these were for pupils who ran away from the institution, confinement being for a week at a time." And this is where Ingersoll becomes involved in the residential school system. I will bring that up a bit later, that quote, but keep that in mind, imprisonment in a cell. One thing we talk about when we talk about the residential school system is intergenerational impacts. How does this impact the successive generations, not just the students who went, but their children and their children? My grandparents, Stanley and Sarah, were both survivors of the Mohawk Institute Residential School. Here on the screen is the identification card for my grandmother when she attended the residential school. You'll see in the top corner, number 0970. Most of the children at the Mohawk Institute were not referred to by their names, they were referred to by their numbers only. So my grandmother would have been referred to as 0970 for the entirety of her time in school, a period of over 10 years. In 1951, the Children's Aid Society of London and Middlesex removed my father from his childhood home, deeming his parents unfit to raise children. And we have his Children's Aid records, and this is what we see in these records, that they say his parents were unfit, they were alcohol addicts, and again, they were systemically abused within this system, and I admittedly do not blame them for that. My father, William Groat, was a prolific guest speaker prior to his death in May 2022, and this is a quote that he gave about his life and about his parents. "I was introduced to my biological parents when I was 7 years old. My parents were bitter because they had no upbringing or no training on how to be parents. They had no childhood themselves. I was roughly 36 years old when we discussed the Mohawk Institute and I learned about the residential school system. They had no parenting and they had abuse throughout the residential schools, so that's all that they knew. They had no upbringing. How could you give something that you don't have yourself? They were struggling with the best they could, with anger and hatred, and trying to support a family when they had none of that themselves. Because in residential schools, they never taught parenting skills, they never showed you love or affection. I used to think that I didn't have any culture, but now I've learned it was taken away from me. My father lived here in Ingersoll for the rest of his adult life. I moved here with him as a child when I was 6 years old. And again, we see these patterns continuing. In 2006, the Children's Aid Society of Oxford County came to my house on Bell Street. At the time, we were struggling financially. We did not have heat and hydro while we were living on Bell Street, and Children's Aid was called to check in on us. Every single form that I have for my own Children's Aid record has a checkbox in the top corner asking if I'm Indigenous. These were all checked off. My Indian status card, my Indian status number was listed on every form, and a copy of every form was sent to the federal government, as they have jurisdiction over me as an Indigenous child living here in Ingersoll. So again, this is not something that does not affect our community. What we know now and what we discuss now about the residential school system is impacted by the IRSSA, the Indian Residential School Settlement Agreement, passed in 2006. It is the largest class action lawsuit in Canadian history. Prior to the IRSSA, there was the Royal Commission on Aboriginal Peoples in 1996. This recognized systemic abuse within federally funded Indian residential schools. So like Florence Nightingale, like Peter Bryce, this is being flagged continuously. After the Royal Commission, there was a dispute resolution process. This was established to compensate survivors of the residential school system based on a points system that considered various forms of abuse, including sexual assault. You were given points based on how badly you were abused, and financial compensation was geared to the amount of points you were given in this legal dispute system. Cultural assimilation was not considered as part of this process, and to this day, The loss of language, the loss of culture is not something that can be tried within a Canadian legal system. By 2005, 13,400 individual lawsuits were filed against the federal government, religious denominations, and individual employees. Class action lawsuits, including a class action called Baxter, representing 90,000 survivors, sought $1.2 billion in compensation. In May 2006, the IRSSA was approved as the largest class action lawsuit in Canadian history. This lawsuit created the Truth and Reconciliation Commission of Canada. Part of its mandate was to produce a report concerning the residential school experience, its history, its purpose, its operation, its supervision, and the intergenerational impacts. 79,309 former students received financial compensation through this class action lawsuit, but this was not given to the families of former students who had since died. So for example, my grandparents died in the 1980s. They were not compensated through this, and their families were not entitled to compensation either. The Truth and Reconciliation Commission of Canada was chaired by the Honourable Murray Sinclair, who later was appointed as a Canadian senator. The IRSSA said that the Truth and Reconciliation Commission, quote, will not duplicate in whole or in part the function of a criminal investigation. There have been no criminal convictions associated with the residential school system. Nobody has gone to prison. This was more of a fact-finding endeavor. And again, this was influenced by other international Truth and Reconciliation Commissions. Notably, South Africa had one in 1996 regarding apartheid, the racial segregation of black and white South Africans. The TRC, quote, could not hold formal hearings. It could not act as a public hearing. It could not conduct a formal legal process. It does not possess subpoena powers. It did not have a right to compel attendance or participation. So again, this is a narrow understanding. The Truth and Reconciliation Commission is not comprehensive. Staff members did not participate in this, even though staff members are still alive. Teachers, administrators, this is from the survivor perspective. The commissioners of the TRC, including Murray Sinclair, traveled across the country between 2008 and 2014. They gathered testimony from 7,000 survivors, primarily those who attended residential school after 1940, because similar to my grandparents, earlier survivors had already died by that point. Murray Sinclair has since noted that the Indian residential school system impacted 7 generations of Indigenous children, noting that we have been denied our identity through a systematic and concerted effort to extinguish our culture, our language, and our spirit. The Truth and Reconciliation Commission included 94 calls to action that are meant to instigate change. I will note the final report of the Truth and Reconciliation came out in 2015. So while I'm very thankful to be here today delivering this presentation, this call to action has been 8 years in the making, 2 full cycles of council, and I think it's always important to consider internally why it might have happened that we haven't had this presentation in the past 8 years. There was 5 calls to action regarding municipal governments. One of them is number 54, the one I'm presenting today, this education session. As I've said, there is more to be done. Anti-racism and intercultural competency certifications is something that I am not able to do. The other 4 calls to action are as follows. 43, adopt and implement the United Nations Declaration on the Rights of Indigenous Peoples as a framework, and I will touch on that briefly in a moment. 47, repudiate the concepts of terra nullius and the doctrine of discovery. So those are statements made by the Pope which governed how Canada was colonized, saying that these lands were not occupied by Christian nations, therefore they were not occupied by legitimate governments, therefore we can occupy them. These are still principles that impact our governance to this day. 75, develop strategies to identify, commemorate, and protect former residential schools within municipal boundaries. That call to action does not impact Ingersoll. And call to action 77, municipal and community archives will provide records pertaining to the residential school system to the National Centre for Truth and Reconciliation in Winnipeg, Manitoba. And this does impact Ingersoll, as I will tell you briefly. Ingersoll does have records relating to the residential school system. For the reference of council, I met with the clerk and the CAO and Mayor Petrie in December, and we discussed number 43, 47, and 77, and how we might move forward with those, and I believe more information will be available later on. I will briefly touch on UNDRIP, the United Nations Declaration on the Rights of Indigenous Peoples. This was ratified in 2007 by the United Nations, and it is deemed an aspirational document, which means it is not legally binding. In 2021, the federal government passed the United Nations Declaration on the Rights of Indigenous Peoples Act, which says that Canada must take all measures necessary to ensure the laws of Canada are consistent with UNDRIP. And again, I would caution the council to treat this as a face value statement, saying that this is something that you endorse because it could have real world impacts. It's not something that's just a checkbox. So only do this if you're actually going to meaningfully do it. Article 11 of UNDRIP states, for example, Indigenous peoples have the right to maintain, protect, and develop archaeological and historical sites and artifacts. If council decides to adopt UNDRIP, as the Truth and Reconciliation says they do, you're building a new multi-recreation center, and we find an archaeological or cultural site that's deeply embedded to us, important to us, we get jurisdiction over it. That's something that you need to consider. Article 18, Indigenous peoples have the right to participate in decision-making in matters that could affect their rights through representatives chosen by themselves. Again, if you're rezoning the municipality, hereditary council is someone who we choose, who we would want to respect us. They have different opinions in the elected council. According to UNDRIP, this is what we are entitled to. Article 25, Indigenous peoples have the right to maintain and strengthen their distinctive spiritual relationships with their traditionally occupied and used lands, territories, and waterways. Again, these are lands that have not been ceded by a lot of Indigenous nations. Article 26, Indigenous peoples have the right to the lands, territories, and resources which they have traditionally owned, occupied, otherwise used, or acquired. Article 26, the claim could be made, the Kanyen'kehaka or Mohawk Nation has never ceded this territory through a treaty. We have rights to this land based on Article 26 of UNDRIP. I very much am fully supportive of UNDRIP, and I think a municipality should act upon it, but I do not want it to be taken at face value as something that is just a checkbox. I asked you to keep in mind imprisonment in a cell, and these are records that directly connect Ingersoll as a municipality with the residential school system. The Ontario Provincial Police both preceded and succeeded the Ingersoll Police Force. OPP occurrence books from 1947 through 1955 from Ingersoll directly connect our community to the Indian residential school system. December 1948, this is from the police occurrence books. 2 boys picked up on Charles Street East. Boys in question stated they had run away from home in Brantford on Monday. Both boys are Indian. Action taken. Reported to district headquarters, who contacted Brantford. Boys will be held in a cell, taken to the Mohawk Institute. December 1949. 2 missing boys located. 2 Indian boys. Mohawk Institute of Brantford came to office, lodged in cells for night, took boys to Brantford. April 1951. Missing boy found from Ingersoll, 4 little Indian boys. After taking chase, he caught one. Action taken, held in office, waiting for authorities. Boys released to Reverend W.A. Zimmerman, the principal of the Mohawk Institute. May 1953, Indian boys at large. Phone call to the effect that these were 2 Indian boys walking west on the tracks, had probably escaped the Indian school in Brantford. We know the abuse that these boys would have experienced. We know that after the Ingersoll police captured them, they were likely imprisoned in a cell for a period of 1 week in the Mohawk Institute residential school. I have redacted these records somewhat. The original records have the names of the boys in question. They were children who had family living here in Ingersoll. These children were sent to the Mohawk Institute. So I have kept that information. Mayor Petrie has been will be provided copies of these records, but again, there are other records out there. We know this. The council can make the decision to assure that original copies of these records are sent on behalf of the town to the National Center for Truth and Reconciliation in Winnipeg, so they are available to families. As a good professor does, I give you further reading to further your own education and your research, just in case you think you don't have enough to consider after this presentation. These are books mostly written by some of my colleagues Adele Perry and Mary Jane Logan McCallum at the top have spoken about urban Indigenous experiences in hospitals and the healthcare system. Rooster Town is about urban Indigenous communities and how Indigenous cultural identity can be impacted by municipal governance. From the Ashes, the story of being Métis, homeless, and finding my way by my colleague Jessie Thistle is about being an urban Indigenous person who's been impacted by intergenerational trauma and addiction and homelessness. Clay We Are Made Of by my friend Sue Hill speaks about Six Nations of the Grand River Reserve, the elected government, the hereditary government, and then the mush hole, Life at Two Residential Schools, is survivor testimonies from the Mohawk Institute and the Mount Elgin Institute. All of the survivors' stories that I quoted today are pulled from that book. And with that, I'm done. So thank you, everyone, for taking the time to listen. And I'm good for questions for like 10 minutes, I think.
We'll take as long as, as long as council has questions. Cody, thank you very much. This is certainly just the start of our journey and learning, and I think you gave us a very good start indeed and a lot to think about. Do you have any suggestions moving forward what our next step should be?
Yes, I do indeed. As I joked to both Mayor Petrie and Deputy Mayor Wilson, I am lucky in that I don't actually have to make these decisions now. I can just tell you all this information and let you go about your way. But looking at these 5 calls to action, I think the first step would be to find a proper organization or company who can deliver intercultural competency training, have council and civil servants engage in that training so that you can fully state you have addressed Call to Action 57, also assuring that Call to Action 57 is something done for each new council term. I think it would be beneficial and advantageous to have a different speaker every time this is done because we all have different perspectives. We don't have uniform opinions on how to approach this, so it'll always be a learning opportunity. Call to Action 77, I can provide a copy of these records assuring that the search is continued to find these occurrence books. I believe there's a bit of confusion as to where they might be now, and assure that they are sent to the National Center for Truth and Reconciliation. And again, seriously consider Call to Action 43 in regards to UNDRIP. Other municipalities are doing this. Vancouver is a leader in regards to UNDRIP. And I think that one thing I often tell people is there's no need to reinvent the wheel. Ingersoll doesn't have to go about this alone. So find what other municipalities are doing and take their advice moving forward as well. That's my 2 cents to start, but I'm open to other questions.
Thank you. Is there any further questions for Mr. Groat? Councillor Halliday, please.
Thank you, Cody. That was a very heartfelt presentation, and it definitely was needed. When it comes to the only thing that most people can do and relate to is when we hear that, yes, we know the lands have been taken. So we try to acknowledge the land. Now, from your perspective, how does that feel, where the least we can do is perhaps acknowledge the land when we start anything, and whether that makes a difference at all to your community?
I think that's a really important question. We're often seeing these discussions of land acknowledgements before council sessions, before any forms of meetings. And I do think that they are relevant, but I think that they can easily transition to becoming very performative and a checkbox and just something that is easy and flashy to do. And then we move on. We've done our 2 bits, we've recognized. I think if we start looking at some of these calls to action, realize that there is serious work that needs to take place, looking at seriously what doing or adopting UNDRIP might mean, and if council prepares a report and says that it's not in their best interest, then I feel they need to be able to hold themselves to accountability and clearly say why it's a decision they're not comfortable making, instead of slowly moving on and not centering it, not giving any justifications for why it's not being adopted. So again, land acknowledgements, yes, I think that they should be done, but again, I think we need to realize that it can be performative, that is the final step. You need to seriously start looking at these other calls to action and assuring that you're providing justifications for why you are or are not doing them as well, and be ready to be held accountable. Yeah, and I don't want to sound angry by saying that, but I think it's very important that we don't just sort of push ourselves under the rug when it gets difficult. I hope that addressed your question.
And I may be able to add something to that. When I first contacted Cody, I'll be honest, I wanted to acknowledge the land here. That King Street out here was the Detroit path, and I didn't know the traditional Indigenous name for it. And I wanted to honor the traditional name of the river. But Cody definitely gave me an education on if you want to make a real difference, this is the way to do it, not with token items. And so I really wanted to go down that path and bring that with council, and so we could learn with the community and move forward respectively, and really do our homework before we do anything else, such as a land acknowledgement. Why are we doing that, and what does that mean? And I think it's important to take slow steps here and really learn and consider everything before any of those things happen, to make sure we know why we're doing things and we know our full, we build those relationships.
And just as a follow-up to that point, when we think about land acknowledgements, and we think about, if we say this is traditional territory, the Haudenosaunee, the Anishinaabe, the Attawandaron, when we recognize that, and then we recognize this is a traditional territory of the Haudenosaunee, there's no treaty signed with the Haudenosaunee to represent this land. So council is clearly recognizing that this is in fact their land, that we do not have a treaty to be here, and that has implications. It's not just a checkbox, it's something that needs to be recognized. And again, other municipalities are considering that. Close to Brantford, where the reserves there are in these active land claims issues, they specifically chose to not do land acknowledgements in case they were held accountable in a court. There's a land claim disputes. The municipality clearly recognizes this is Haudenosaunee territory. No treaty has been signed. So again, this is not a checkbox. It's something to keep in mind. I'm still thinking there's a way to go about it, but we need to recognize that this is not just performative, especially when it comes to a government who is making these claims. That's why provincially and federally you don't see land acknowledgements before legislative sessions for that exact purpose.
Any further questions or comments? Deputy Mayor Wilson, please.
Thank you, Cody, very, very much. I think everybody appreciated it, and lots of people in the crowd and listening online, so we know there's certainly an appetite to learn together. So in this circumstance, it's my understanding that we didn't compensate you for this presentation because you see it as part of your work at the university, and we're very lucky for that and certainly appreciative. But I also don't think we want to set the expectation that this type of education should always be free.
Yes.
So I guess I'm just curious from your perspective what compensation should look like when we're thinking about right relations in this type of education in the future.
I think that's a very important question. We often see, for instance, in my profession, reaching out to elders or knowledge keepers or traditional community members who can provide us context and information in this in regards to our scholarship, and we do assure honorariums are in place to appropriately remunerate them for that information, for that knowledge. There's been times when I have delivered presentations and I have been compensated depending on the setting. I'm doing this in my role as an academic today, so I don't need to be. But I think the first instance that council will need to recognize, so if you are consulting with the elected council of Six Nations of the Grand River, in my opinion, you would not need to compensate. They're elected officials who have been elected to their office, and they are municipal, essentially involved in municipal governance. I think if the town began to approach hereditary council, which is still in place, to assure that both councils are appropriately consulted, our hereditary council that's always been in place, I think that's an instance where you can discuss honorariums and compensation because they are traditional governance leaders. Consulting with municipalities is not within their political position. So again, that might be an instance where you look at the differences in compensation. And again, it's very geared to the community. So offering it is important. They might not accept it, which is fine. They might expect it, which is also fine in my opinion. But again, it's just looking at the position that somebody is in and how you're asking them to share their knowledge and their insight. If I were an Indigenous community member who is not also an academic, I would probably be expecting compensation for this presentation. But yeah, it's very case specific, and Mayor Petrie has my information if he wants to ask a specific example. Yeah.
Excellent. Are there any further questions? Seeing none, thank you very much, Professor Groat. I will now call upon Councillor Hudson for a motion to receive the presentation, please.
Thank you. Moved by myself, seconded by Councillor Van Kooten-Bossens, that the Council of the Corporation of the Town of Ingersoll receive the presentation from Cody Groat, Assistant Professor of History and Indigenous Studies at Western University, on the Truth and Reconciliation Commission of the 57th Call to Action.
Excellent. Is there any discussion on that? All in favor? Opposed? That is carried. Okay, seeing how it is 7 p.m., we will now move into the public meeting portion of our agenda. So the first one will be on item CP 2023-57, that is, ZN 6-2209-265 Ingersoll Street, Ingrox Limited. So, I declare the public meeting to be open. This meeting is being constituted as a public meeting held under the Planning Act for the purpose of hearing identified zoning amendment proposals. This meeting is also intended to provide the opportunity to any person in attendance to make a presentation to council. Anyone in virtual attendance who wishes to receive the decision of council on any application being considered this evening must submit a written request to the town clerk, Danielle Richard, at danielle.richard@ingersoll.ca. The Ontario Land Tribunal has the power to dismiss any appeal under subsection 25 if an appellant has not provided counsel with oral submissions at a public meeting or written submission before a bylaw is passed under this section. So the first is the zone amendment application for ZN 6-2209-265 Ingersoll Street, applicant Ingrox Limited. This application, does any members of the council have a conflict of interest on this application being heard this evening? Seeing none. Has the clerk received any additional correspondence on the application that is not noted on the agenda?
I have not.
Thank you. I now request Planner Ron Verstegen to provide an overview of the application and an explanation of the requested zoning amendment.
Thank you, Your Worship. Can you hear me?
I can, thank you.
Okay, great. Okay, first application for council's consideration is a property on the corner of Glen Ave and Whitty Ave. It's actually, the intent is to rezone the subject lands from an MR to an MR to R1 in order to construct a single detached dwelling on the subject parcel. Now, this application has been submitted in support of a severance application that was considered by the County Land Division Committee in January of this year and was conditionally approved. One of the conditions is that the lot that we're dealing with tonight be rezoned to R1. The parcel itself is approximately 616 square meters in area and have a frontage of approximately 20.1 meters along Whitty Ave. Surrounding land uses are primarily single detached dwellings and semis to the southeast and east. And then we have industrial uses to the north and to the west, which include Atlantic Packaging, Cami Automotive, and Fastenal Canada. In terms of the application itself, the applicant also submitted a noise study, which I believe is also attached to the agenda for council's consideration. And just to quickly go through that noise study, considering the immediate industrial uses, notwithstanding that, the report did indicate that the stationary noise levels at the point of reception are below the Ministry of Environment's noise level limits, and also recommended that no additional requirements in terms of ventilation, acoustical barriers, or warning clauses were necessary in order for the residential severance to be completed. In terms of comments that were received, as the clerks indicated, there was one comment that was actually two comments that are attached to the agenda for council's consideration. The first is actually directed to the Land Division Committee, while the second is submitted in support of, in respect to, the zone change application. And those are from Mr. Lobson. So just to quickly identify the concerns, Mr. Lobson indicated that he acknowledged that the entirety of the property was part of a road allowance, which extended from where it currently terminates through to Ingersoll Street. And previously that the Trails Committee had identified this as a potential link to link the subdivision through to Ingersoll Street. However, those lands were ultimately sold to Ingerox and merged with the parcel that currently occupied by Fastenal. So Mr. Lobson indicated that if the zone change was denied, then the severance could fail. Now, he does suggest that there's an opportunity here for the town to approach Ingerox to either hive off a portion of that property to continue it to provide a linkage opportunity through to Ingersoll Street through either a purchase or a lease or a land swap. And he also suggests that there would be even still remaining area for a dwelling to be constructed on the lot to be, the lot to be rezoned. Beyond that, there was no other comments, and that's the extent of my presentation, Your Worship.
Thank you, Mr. Verstegen. Does the applicant or the representative have any comments or anything to say concerning the application? Absolutely. If you just come up to the podium, or the lectern, sorry.
Good evening. Thank you for having me. I'm Derek Truelove, representation for Ingerox Limited. I did have quite a few comments. I think it provides a little bit more context for the property and the surrounding use. And it's basically the same presentation I provided to the committee adjustment prior to their decision. As part of the noise study that I provided from Burnside, I do have, I guess everybody has access to it, but it was at page 29. There's a good satellite map. Does everybody have access to that map? I have additional copies as well if you required a hard copy. Okay. So, oh, it's perfect. Thank you. Yep. Thank you. So, as noted by planning staff, the proposed lot to be rezoned is bordered by two industrial properties, Fastenal to the west and Atlantic Packaging to the north. Now, I understand that both of these facilities have been in place for quite some time, along with the surrounding residential subdivision. Now, with respect to Fastenal, the proposed lot to be rezoned is a similar distance away from the operations of the existing residential adjacent lots to the south of the proposed lot. Accordingly, the focus of this matter appears to be the proximity to the Atlantic Packaging facility to the north. Now, a few things that isn't shown as part of the planning reports and isn't readily available is that for the Atlantic Packaging facility, the side of the building abutting Glen Avenue is a solid wall, and currently there are no open or glass windows. There does not appear to be any storage of materials that would create an adverse impact or outdoor storage of materials at all. And then, although difficult to make out, there's already an existing 6-foot tall wood board fence that runs all the way along Glen Avenue, runs the length of the proposed lot. In other words, there's already existing mitigating factors between the two uses for the rezoning purposes. There was, in the early reports from Mr. Verstegen, there was concerns about adverse effects, specifically dust, noise, and vibrations, but there's no evidence of these adverse effects being transmitted from the Atlantic Packaging site. Although the proposed lot shares a property line with the north of the Atlantic Packaging facility, it should be noted that the entire 1/3 northern section of the lot is, there's an easement, existing easement along there, so any placement of the house has to be on the southern part of that proposed lot. So a little bit further away gives a little bit more buffer for that area. So. And in terms of, in general, we've had a noise study done as indicated by Mr. Verstegen, so that's part of the materials that's been submitted today. That noise study was conducted with cooperation from Atlantic Packaging, which would, they were open to the process in terms of that, and there was no issues, no noise issues identified as part of that study. Page 30 of the report actually shows a graphic of the potential noise levels issues in where the noise impact is from that facility. And as you can see that the focus of the area is on the parking lot area to the kind of the northwest. So it would have impact on potential existing residential houses, but it doesn't have the same impact on where the proposed lot will be. Now, turning back to page 29, in terms of the proximity to the Atlantic facility, and the other houses in the area, I think from looking at that satellite image, I think it tells a little bit of a story. Because as you can see, Council, there is probably about 5 houses in the immediate vicinity that have essentially in-ground swimming pools. And so to me, that kind of speaks to the intent of those homeowners to say, not only do we enjoy the outdoor space, despite being close to these facilities, we enjoy it so much that we're going to invest into, spend a lot of money into our backyard to install a swimming pool for both, short and long-term use. They're clearly enjoying those outdoor spaces. And I don't think this proposed lot is much further away. This is really very close in terms of the distance differences in terms of those existing uses, so. No concerns, no objections have been raised by Atlantic Packaging or Fastenal with respect to the proposed rezoning. And at the Committee of Adjustment meeting, it was brought up that the use of the property to the north could change in the future. And yes, that's correct. Over time, changes can be made to uses. But again, my submission in that would be that if there's a change in that use to the property to the north, that it would have a similar impact on the adjacent houses to the west and the south already existing in that neighborhood. And so any rezoning or change of use in there would have to take into consideration those existing houses as well as a new proposed lot. So now with respect to the letter from Mr. Tim Lubsam, on page 11 of Mr. Versteegen's report, there is measurements on a reference plan. And I understand what Mr. Lubsam is saying, but really in terms of the Ingrox property that we're speaking of, you'll see there's only about 1.5, 1.6 meters between the existing asphalt driveway and the property line. And that's a main route for vehicles coming beside the Fastenal building to get to the rear of the property. So from my perspective, it's not really a large enough area to create a trail. And then that area is actually a slope off into a ditch where those hydro pools are running along the north of the property. I did look at satellite imagery before tonight's meeting, and there seems to be a trail, but it's mostly on the Atlantic Packaging site in terms of what was shown on that satellite imaging in terms of there may have been a trail in the past used in that area, but there's certainly not enough area on the Ingrox property to establish a trail, and the slope is not appropriate. In any event, such a requirement for this type of matter is not really contemplated by the Planning Act to require a landowner to sever off additional lands for a trail purpose, for this purpose of the decision of this matter. So, with respect to when we're dealing with planning matters, obviously we have to look at the provincial policy statement and the official plan, and they both speak to efficient land use and an intensification of redevelopment where appropriate. And the one thing that has not been commented on is if you kind of look at the configuration of the Fastenal property, and that, this area, it was originally intended to be part of a road which didn't come to fruition. Obviously, that's been closed out and has become part of the Fastenal property. But what it's created is a little stub area, which would be, in my mind, a useless parcel of land moving forward in the future. It's too close, for them to put in a building on. It's an awkward shape. It's right next to, immediately right next to a residential house. And so we look at what's a better use of the property, and the residential use would be more consistent with the exact, property right next door. If the rezoning is not allowed, the severance is not allowed, then essentially we're just creating an area that is, again, a useless area of land. It won't be good for commercial industrial use, and it won't be good for residential use. As everyone is aware, rents for housing are at an all-time high, housing costs are at an all-time high, and our province continues to face a housing shortage. Now, although this is just one lot, I think, really in terms of when we look at each matter that comes before us, we should take into consideration that housing shortage, and that, basically that can only be made up by one lot at a time, or many lots at a time. But this is just one step in the right direction towards helping and alleviating that issue. It's respectfully submitted that the rezoning should be granted. So I'm happy to answer any questions that anybody may have.
Certainly, once we get to that portion, I'll gladly direct those questions to you, sir. So, right now, I will open this meeting to comments from the public. This portion of the meeting provides the opportunity for individuals to speak to the application and have their comments considered by the planner and council before the report and recommendation on the requested zoning amendment is brought forward at a subsequent meeting. Any persons from the audience who wishes to provide comments in support or opposition of the application may do so now by coming forward to the lectern, stating their name and address for the public record. Is there anybody in the public who would like to speak towards this application? Seeing none. Now, members of council now have the opportunity to ask any questions about the application. However, they may not offer any comments at this time. Are there any questions of this application from council? Seeing none. If there are no further comments or questions, then the public meeting for this application is concluded. The application will now be scheduled to come before council at a subsequent meeting during which the planner's report and recommendation will be considered. And then, given that, I will ask that Councillor Hallerou move a motion to receive the planner's report, please.
All right, thank you. Through you, Mayor. Moved by myself, Councillor Hallerou, seconded by Councillor Hudson, that the Council of the Corporation of the Town of Ingersoll receive Planner's Report number CP 202357 as information.
Discussion? All those in favor? Opposed? That is carried. Thank you very much. Thank you. Now, we were going to have a separate delegation, but that was from Mr. Truelove, but that was taken care of in the public meeting. So you're okay with your presentation and not presenting again? Excellent. Well, then we will move on to the next one, which is the application for ZN 6-22-10 Keith Maybe Boulevard, owner 1879784 Ontario, Inc. And I know we do have people in the audience for this. This is a reminder that the application will not be decided tonight. This is a public information to get information for it. We will have the opportunity for the public to speak. When that time happens, I will ask that just to make sure the meeting keeps moving along. If you have a comment, please make it. But if someone else has already made that comment or if you've submitted your comments, I would ask that we don't have repeats just to make sure that that's on the record. But if you have something different to add, please fully take advantage of the situation to make those comments. With that, the application being heard concerns ZN 6-22-10 Keith Maybe Boulevard, owner 1879784 Ontario, Inc. Does any member of council have a conflict of interest on this application being heard this evening? Seeing none, has the clerk received any additional correspondence on the application that is not noted on the agenda?
I did receive further correspondence today, March the 6th, from the owners of 43 Fuller Drive. That correspondence has since been added to the agenda, so I won't read through the entire email, but it is included on the agenda and attached to Planner Ron Versteegen's report.
Excellent. I now request that Planner Ron Versteegen to provide an overview of the application and an explanation of the requested zoning amendment, please.
Thank you, Your Worship. Next application for the committee's consideration or council's consideration, as mentioned, is a zone change and associated draft plan of subdivision that's shown on plate 1 of the planning report. The intent is to rezone the subdeck lands from development to a combination of R3 and R3 specials to accommodate the development of the lands for 7 residential lots for single-family dwellings. There's 6 blocks for street-fronting townhouses for a total of 46 dwelling units, and also a residential block, block 14, that would accommodate 30 residential townhouse units to be developed through a future plan of condominium. The application also represents an extension of Keith Maybe Boulevard and Fuller Drive to connect plate 3 of the application or the report shows the intended road connection that is proposed to be extended as part of the application. And as mentioned, all of the development above it, I've mentioned already, represents a total dwelling unit count of 83 units. The lands are generally sloped from the northwest to the southeast. In terms of surrounding land uses, we have predominantly single detached dwellings in the immediate area, and there is the aforementioned stormwater management pond that is located to the south of the subdeck lands. Now, as plate 3 shows, there also is an additional arm that kind of extends from the property to Harris Street, and their understanding is the applicant is intending to retain that land to provide for a walkway connection for Block 14. Plate 4 of the planning report shows the actual development that is proposed as part of this application. Now, in terms of other surrounding land uses in the immediate area, we do have Centennial Park and Victoria Park, which is located on the west side of Harris Street. And we also have a Lorne Moon Park, which is located to the north by approximately 250 meters or a little over 800 feet. We also have additional 3 elementary schools in the immediate area that would presumably accommodate any students that would be generated by this development. In terms of the lands, they are designated for low-density residential purposes. And as detailed on the bottom page of page 4 and on top of page 5, low-density residential areas are primarily to be developed for a variety of low-density forms of housing, including singles, semi-detached dwellings, duplexes, converted dwellings, quadruplexes, townhouses, and low-density cluster development. Additionally, there is a density range in the low-density provision, which basically establishes in the policy that the upper limit is to be approximately 30 units per hectare or 12 units per acre. So that's the high end of the range for the low-density development. And the low end of that density range is 15 units per hectare or 6 units per acre. Now, this particular development itself, being the number of units, would represent an approximate calculation of 29.4 units per hectare. So it falls at the upper end of the low density range. In terms of other policies, they do speak to encouraging a tenure mix throughout a development for a variety of housing types and ownership opportunities, be it rental, cooperative, or freestyle or freehold developments. The lands, as mentioned in the report, are zoned development in the zoning bylaw. And I think it's important to note here that the development zone really represents a fact that there's an acknowledgement that these lands can be developed for development. They are designated. What the development zone really represents is, in effect, a holding zone waiting for a specific development application to come along that would enable the zoning to be refined to reflect the proposed development. In terms of comments from the neighbors, there has been a number of comments that are attached to the report. And as opposed to going through each one, and I know I've heard there's a number of residents that are there, and I don't know if they're intending to speak to the matter or not, but what I'll try to do is maybe summarize some of the comments. The committee or council will indulge me. First being that the proposed development has too many units on a quiet street. There is numerous comments that suggest that the development is high density residential development. Proposed development is not consistent with the development in the immediate area, and there is no consideration of the existing residential properties. Concerns cited with respect to traffic as a result of the development, concerns that it would represent or add to any traffic study it would create traffic concerns and question whether a traffic study has been generated. The concerns now that Keith Mabey will now be a through road. This would result from a considerable increase of traffic from the residential properties to the south, and also indicated in some comments that Keith Mabey was promised to be maintained as a cul-de-sac. Others did acknowledge, however, that they're aware that Keith Maybe may be extended, but were indicated that the development on the Keith Maybe would only be for single-family dwelling at a similar density as what is currently developed. There has been a concept plan that's been provided as an option for the developer to be considered. And again, the comments from the neighbors speaking to a request for the developer to consider other forms of development on this parcel. Comments that the town should investigate extending Fuller to Harris Street from where it currently terminates. Also comments about Walker Road being extended to the south to connect to Clark Road to provide another exit for this development. There's also comments with respect to questioning whether this is for affordable housing purposes, and a comment with respect to low-cost housing, comments with respect to environmental impacts on the property as a result of this development, and then questions about the trail system being provided, as there's nothing currently maintained in the immediate area, and comments whether this is going to create on-street parking issues, and finally, a comment with no amenity area being provided within the development. Subject to any questions from council, that's the extent of my presentation.
Thank you very much, Mr. Verstegen. Does the applicant or the representative have any comments or anything to say concerning the application? Yep.
Thank you. I think we have a presentation.
Okay. I'll just remind that there is a 10-minute time limit. So,
Absolutely.
thank you.
You'll probably find it faster than I will. Oh, that's you, isn't it? Yeah, that's me. I'll put it on the screen. Absolutely. Thank you, Mr. Mayor. I'll start while she's putting it on the screen. I'm Amanda Stellings. I'm a planner at GSP Group. I'm representing the landowner for the applications. We actually do have Paul Florica here as well. He is the landowner. And I'm just going to give him a minute to introduce himself and his company to you guys.
Good evening, everyone. I'd take this opportunity to introduce myself. I am Paul Florica, and we've been developing parcels within Ingersoll since about 2005. We wish to hopefully also start building custom homes in the area as soon as Walker Road opens up. We look forward to that. And I just want to thank everyone for coming this evening.
Perfect, thank you. So just to start with, Ron had done a good overview, so thank you, Ron. As he mentioned, it is in the southeast corner of Ingersoll. The property is currently vacant. It's about 3.34 hectares, and it does have frontage onto Fuller, Keith Maybe, and Harris Street at the moment. It's kind of in a little bit of a transitioning area, as you can see from the aerial, which might be a little bit dated, but there is a lot of developments either that are approved or coming into the area. You can see it's mostly single detached dwellings surrounding, but there are some new developments that do have townhouses in the area. And as Ron mentioned, it's quite strategically located to several schools and parks as well. So on the screen is the proposed development. As Ron mentioned, we've got a combination of single detached townhouse dwellings. So the main difference between them being that the street townhouses have direct access onto that new road versus the cluster development being a private condominium. And as Ron mentioned, a new road is proposed that would link up Fuller Drive to Keith Maybe Boulevard. There is a small portion of the site you can see sort of on the south corner there. A small little corner has a woodlot and there's a buffer associated with it. There's no other natural heritage features on the site, and through this we are proposing to maintain that area as an amenity space for the condo corporation. I'm just going to highlight a couple aspects of the development. So the single detached dwellings that we've proposed, for compatibility purposes, wherever a side lot of an existing dwelling is, we have proposed a single detached next to it. There's 7 lots in total, and they would have access onto the new road. The street townhouses, so these ones, like I said, they would have driveways and servicing on the municipal road. They would be subject to future applications, so part lot control would divide them up so that future purchasers could come. And the last component is the condominium block. So these would be townhouses very aesthetically similar to the street fronting townhouse, the main difference being that they've got a private road, they've got amenity space, and they have visitor parking spaces. So those are elements that the condominium corporation would maintain, including the road over the long term. There is a slight sliver, you can see the arrow where that trail is proposed. And because it does hook up to the condominium road, we have proposed it to be a private trail for the condo. And as I mentioned, the amenity space, there's 2 sections and 2 different areas for visitor parking, so that's really intended to assist with the new townhouses in the area, that visitors could come and have some exclusive parking. In general, I think the intent of the development is to provide a compatible built form. The height limit in the official plan is 3 stories. We've got 2 stories proposed, which would be somewhat similar in height to what already exists in the area. And we have provided a bit of a transition in from the single detached to the townhouse dwellings, and that's to provide a little bit more of a compatibility with the existing residences, recognizing that townhouses generally are considered compatible with towns because they're a similar height, they're just a bit of a smaller lot. So as Ron mentioned, the lands are designated low-density residential, so that permits a maximum of 30 units per hectare, and it permits a maximum height of 3 stories. So the intent of this application is to fully conform with the official plan, and it is consistent with all the policies looking at development types. As was previously mentioned, there is a need for housing in the area, so what we're trying to do is provide that while also maintaining the current designation that exists. The existing zoning is development, so like Ron said, essentially it's a holding zone. It's a zone that recognizes it's intended for residential, it just hasn't been flushed out, we'll say, through the zoning process. So through this application then, we would take that development zone and we are proposing to rezone it. So the 3 main components that we're looking at, the residential lots are proposed to be zoned R1. That's the residential one. It's intended for single detached dwellings, and that's what the single detached houses in the area would, surrounding area would be. The residential type 3 zone is a townhouse zone. Some of the site specifics that we are proposing are to be consistent with some of the development standards in the area and some of the other applications that have been approved relating to frontage, side yard, and exterior yard. I will note on the zoning bylaw that the street townhouses that directly back onto the existing single detached dwellings will have a 7.5 meter rear yard, so it's almost 30 feet. So they will be set back quite a distance with the zoning that we're proposing. Then that tiny little corner at the bottom would be the space that represents the woodlot that exists on the site. And that would be intended so that no structures or buildings would be able to put on there in the future. And we recognize that through the amenity space that's provided. So the zoning bylaw amendment's the one application. The other application we have before you is the draft plan of subdivision. So this is essentially just dividing the land into blocks. Again, we've got a couple more applications ahead of us. So the townhouse, street townhouses would go through a part lot control application, get divided. The condo block would be subject to site plan control, as well as a condo application, which would establish exactly which parts each owner owns and the shared elements or the common elements that would be part of the application. So I just want to mention we have received the concerns to date, and we recognize that there's some challenges with putting some infill development in the area. This site really is kind of a hole in the donut when you look at development. There's development all around it, but it really provides an opportunity to link the street together. The 2 roads had been stubbed intentionally, that they would connect at some point. And as it relates to traffic, we did do a consultation with the county. We had a pre-consultation which determined what would be required with the submission, which was a planning report and a traffic report. Understanding it is a concern, we're willing to take that back and maybe get a bit of input if you guys so desire, but generally the number of units being proposed aren't something that would trigger a traffic report through the county. And I think that essentially addresses most of my points, but I'm happy to answer any questions or if you'd like to circle back after hearing from anybody else. Thank you.
Thank you very much. And yes, we will circle back. Thank you very much. I will now open this meeting to comments from the public. This portion of the meeting provides the opportunity for individuals to speak to the application and have their comments considered by the planner and council before the report and recommendation of the requested zoning amendment is brought forward at a subsequent meeting. Any person from the audience who wishes to provide comments in support or opposition of the application may do so by coming forward to the lectern, stating their name and address for the public record. Any person registered to comment virtually to provide comments in support or opposition to the application may do so when invited to speak by stating their name and address for the public record. And therefore, I do know we do have someone, we do have a Darlene Van Dyke who's available, who is registered. Is that correct, Paula? Yes, I will ask Darlene to start this off as well, please, with a virtual attendance. Tricia Knott has also registered, but she has not joined us. Okay. So now I'll open the floor. Who would ever like to come up to the lectern and speak? Thank you. And just a reminder, state your name and address.
Good evening, Mayor Petrie, members of council, town and county staff, and fellow residents. My name's Ann Wright, and together with my husband, Rob McDonald, we are the property owners at 9 Keith Maybe Boulevard. And we'd like to take the opportunity to express our concerns regarding the application currently before you tonight as information. We're not opposed to the development of the subject property, but we are opposed to the current proposed draft plan of subdivision. Should this subdivision be approved, we, as do other residents of Keith Maybe, would like our road to remain as a cul-de-sac, as it was presented to us upon the time of purchase of our property we purchased in 2015. At the time of purchase of our property, the developer would only sell a lot to us if they received the proposed house drawings and plans, and he would approve them. If he did not approve our plans, we were not allowed to sell the lot or to buy the lot. We were told that this requirement was so that all the homes built on the street would be consistent. Our plans were reviewed and approved, and we were able to purchase our lot and commence building our home with the assurance that all the houses on our cul-de-sac would be in keeping with each other. We always knew that one day the subject property would be developed, but we were led to believe that Keith Maybe Boulevard would remain a cul-de-sac. Having Keith Maybe remain as a cul-de-sac would not be uncommon in Ingersoll or within even our immediate neighborhood. There are a total of 8 other cul-de-sacs just within our immediate neighborhood. Ours is Keith Maybe. We have Lockheed Court, McMillan Court, Stonegate, Bainan, Norsworthy, Woodview, Oakdale, and Gayfer Place, all just within our immediate neighborhood. Since my husband and I are residents of Keith Maybe Boulevard, I will only speak to some of our concerns on the impact of Keith Maybe. However, I understand from talking with others that residents on David Street, Owen Street, Fuller Drive, and Harris also have concerns with the application as proposed. We have concerns with the impact on traffic that the proposed subdivision would have on our street, Keith Maybe, if it was extended. Our concerns in relation to traffic impacts are as follows: that the current width and construction of the roadway would not accommodate the volume of traffic and parking that the proposed subdivision would create on the existing section of Keith Maybe. and for the traffic turning off and on to Keith Maybe from David Street, and then on from David Street to Harris Street. It would be some of an impact there at an already busy area. As well, we are concerned that the safety of our children and grandchildren due to the increase of traffic that will occur and the number of cars that would park on the road as overflow from the townhouse area and proposed condos. Will there be sufficient parking for the new development? Will parking be allowed on both sides of our street? If so, we already know that there's not enough room on the street for cars to be parked on both sides of the street and 2 lanes of traffic flow to get through. If approved, I hope these issues will be addressed adequately in the site plan control process. Under section 9.2.4.1 of the official plan entitled Low Density Residential Areas, it sets out criteria for multiple units. Multiple unit dwellings, such as a townhouse and cluster developments within internal roads in low density residential areas, which this is, will generally be restricted to the following areas, and it cites sites which are abut to arterial or collector roads, or are situated on that traffic impacts from the site create a minimum disturbance on the local streets. We are also concerned that the proposed townhomes that are suggested to be built on the Keith Maybe extension are not in keeping with the town land use policies as detailed in the official plan. The official plan states that in section 9.2.1, entitled Strategic Approach under the heading of Compatible Development, that council should ensure that new housing is of a human scale and sensitive to and improves the existing physical character of the area. Section 9.2.25, entitled Residential Intensification, also says, in relation to size and location, that it is not intended that residential intensification will occur uniformly throughout the town. The location and form of residential intensification will be determined by the policies of the various land use designations, with the intention of permitting small-scale developments in area designated as low residential and directing larger-scale projects to areas as medium and high-density residential and central area. This property, however, is currently designated as low-density residential in the town's residential density plan. Then section 9.2.3, entitled Objectives for All Residential Designations, also says that council ensure the built form, massing and profile of new housing is well integrated and compatible with the existing housing, and that a compatible transition between the lands of different residential densities. Adding just a couple more single dwelling homes isn't really making that change any different. It's just adding 2 more houses and then moving on to the townhouse area. The draft plan of subdivision that is currently proposed is not in keeping with the existing housing on Keith Maybe Boulevard. Is laid out in the long-range planning framework to develop the town of Ingersoll detailed in the official plan. I understand that the application is in front of you this evening as information and that no decision or recommendation will be made this evening. I am hoping that this development will not be rushed through, but rather due diligence and appropriate time be taken so that a good solid plan can be created, one that the current residents and future residents of the neighborhood will enjoy. It is also my hope that Town Council will direct staff to work with the developer to come up with a plan of subdivision that takes into account the concerns that you've heard tonight and that is in accordance with our official plan and policies. A plan that benefits the town, the current residents in the area of the development, and not just that of the developer. As all the other residents on Keith Maybe have expressed, we too would like to see Keith Maybe remain a cul-de-sac, and that the street be completed with other single-family dwellings, custom homes, in keeping with the rest of the street. And further, that I'd like to see the draft plan of subdivision be amended to be required that the strip of land on the subject lands to Harris Street be constructed as the main entrance and exit to the new subdivision. That's all for my thoughts tonight, and I want to thank you for giving me this opportunity to speak and for listening to my concerns.
Thank you very much. Is there anybody else who would like to speak to the application? Sorry, I will, sorry. Just part of the process, we have to have respect for each side, and so we don't allow signs of appreciation on either side, okay? Just to be fair. Thank you.
Thanks, Your Worship and Council, for allowing me to speak. Harry Van Dyke. I reside at 43 Fuller Drive in Ingersoll. It's been a little while since I've been in front of council, so I apologize for any of my potential informalities. I do support what Ann has spoke to and expressed some concerns. I don't necessarily challenge the development in the sense of we do need to have sustainable housing. We do need affordable housing for those. What's unclear to us, I think, is, from my own perspective, is what will be the condo development. You know, having learned some things tonight with access of the trail from the condo to Harris Street, it's great that the condo has access to Harris Street, but my kids, my wife, there's no formal access for us to gain access to the Cheese Museum Park. We have to walk up to Owen, down Harris, and then work our way. Or we bootleg through the floodplains and cross Highway 19 and hope it's not raining and we don't get wet because of the splashing of the vehicles and whatnot. So I guess there's an opportunity here to incorporate the development into the overall neighborhood and deal with some of the lagging legacy issues that we do have as a result of a number of developers taking over certain aspects of the development. The pond, the trails. I think everyone can agree that we want to have more open spaces for our kids, for our family, to walk around and enjoy nature. There's a perfect opportunity there with the pond, the conservation area, further development south, and incorporate those things. I have sent an email through to planning and council for a number of my other comments, more from a technical perspective. But again, I don't think we want to stall the development. My intention is not to stall. I think we just want to make sure that it's incorporated and the town sees this as an opportunity to have the developer do more. Not just develop 82 units within a 7-acre lot, but take on some of the responsibility and make more open spaces and make more trails and create Ingersoll and put it on the map with respect to, hey, this is a great place to live. So thank you for your time. Appreciate it.
Thank you very much. Just back to my further comments, the reason why I don't allow applause or anything like that, we want this to be an open public meeting where there may be some people before and against, so we don't want to have anybody on either side be intimidated and not come up and express their views, and that's really what it is. It's about respect for both sides, and so applause all you want inside or afterwards, but just to make sure that it's an open space where everybody can share their thoughts. So I will ask, is there anybody else who'd like to speak to the application? Yeah, please come forward.
Good evening. My name's Tricia Knott, and I live at 6 Keith Maybe Boulevard. I'm one of the residents on that boulevard, and I have submitted a letter of concern to council to be considered. I just had a few other things to say in further looking at the plans and what's been provided. I went to the County of Oxford official plan and looked at Schedule I-4, I guess it is, in regards to the wellhead protection area of the plan of the area. And I'd note that the property that we're looking at for development has part of it is included in that wellhead protection area plan. Part of it is within the 100-meter buffer zone, and part of it is within the wellhead protection area 2-year time of travel zone. So it has been identified as an area that is vulnerable to development and the concerns, environmental concerns that go along with development and different kinds of development on that land. The plan itself indicates that there are such studies as watershed and sub-watershed planning studies that need to occur or have occurred and need to be considered. It indicates that an applicant seeking approval of a development application will be required to submit a site plan as part of a complete application that addresses matters such as surface water drainage, proposed sediment and erosion control measures, location of proposed building and structures, and location and design of any infrastructure, facilities, and plantings required to implement sub-watershed study recommendations. So that's really my concern, is that it's a sensitive area. It's a sensitive area for the with environmental concerns. I've talked about that in my letter of concern, and these things should be considered by council. Further, in the official plan, it indicates as part of the development approval, County Council and the Area Council shall implement development control measures recommended through the development review and consultation process. So I think that that's really what I had to say on that topic, is that it just really needs to be reviewed, and I think some studies need to be taken a look at, and make sure that such development is not infringing upon the environment in the area. And the rest of my concerns have already been addressed.
Excellent. Thank you very much. Any further comments on the application? Nope. Please.
Good evening, council and staff and fellow members of the community. My name is Mike Farlow. I live on Francis Street, which is not part of the nearby community that's involved in this, but I'm part of an organization called Transition to Less Waste, and part of what, a large part of what we're involved in is researching and developing transitional towns. And a big part of that is promoting the development of livable communities. And so I've got a couple of questions I just have for clarification on regarding the report. That's CP 2023-58. It talks about affordable housing, and I wondered what is considered affordable housing. I assume there's a price point that is being used in the definition, and
Okay. Mr. Verstegen, would you like to comment at this time?
Yeah, Your Worship. I'm not sure. I think the applicant has indicated that there is an intent to develop this for some form of seniors community, but I don't know if there's ever been any information relayed to us in terms of any price point of the units. So again, whether we're talking affordable as per any subsidization from county or from the provincial funding, I haven't heard of that, but I don't know if maybe the developer may be able to speak to that.
Thank you, Mr. Verstegen. Would the applicant like to comment on that question at all?
well, I assume there's a price point that we're trying to service the community with, and I wondered if we have a price point, and then is any of this development intended for affordable housing based on that price point?
Okay, at this time, there's no affordable housing as defined, proposed in the development. Affordable housing, I believe, is 80% as defined by the CMHC of what a market unit would be, and they've got sort of processes and requirements for affordable housing. So at this point, there's no affordable housing proposed in the development that would meet that CMHC definition.
Okay, thank you. No, I appreciate that clarification. I know on page 4 of the report, it states that to meet projected market-based and affordable housing needs of current and future residents of the regional market area, and that would be Ingersoll, and that would be the area. So this definitely does not, is not developed to meet that requirement of affordable housing. Is that an accurate statement?
Mr. Greaves.
Good to see you, Mike. I think that is an accurate statement. I think that's what I'm hearing, is that it's not proposed.
Okay, and my understanding that the county has an actual price point for affordable housing in our community, and I think it's $427,000. And so I'm assuming, because it's not set up for affordable housing, that this would not be at that price point. And I guess with transition, we're always hearing terms and trying to determine exactly what is meant by affordable housing. And so if 427,000 is the price point that if you're under, it's considered affordable housing in Ingersoll, then if you're making $60,000 a year, that's after taxes, and a third of your income is to go to housing, that would provide you with $20,000 a year, or $1,660 a month, which would be you could have, at 5%, you could get over 25 years a $380,000 mortgage. So affordable housing is not for somebody that, if you're above that level, is not for somebody that makes $60,000, $60,000 a year. Even at $90,000, you could afford a $570,000 mortgage, but that's not including, that would be after taxes. That would not include the taxes you would have to pay, the insurance, the down payment, and utilities. So if part of the goal of council is looking for affordable housing, that sort of gives us an idea to which income, like it'd have to be 120 people making 120,000 plus to be able to afford any of these new developments. I think it would give them a $760,000 mortgage, 5% over 25 years. That's if you meet the stress test, which there's a good chance you couldn't. I don't know if you're aware of how that works, but it just makes it tougher to get a mortgage. And so I guess that's something I wanted cleared up. Is this affordable housing, and what are we talking about when we're talking affordable housing? The other thing, and I just got this report, or picked up this report today, so I just have maybe an idea. I haven't had the pleasure of talking to members of the community, but I know one of the things that Transition to Less Waste is concerned about is the impact of change on established communities. And I know myself, just even having a street widened can just speed up traffic dramatically. If retaining walls are put up because you're cutting into part of what was a hill or something, then it can totally change the character of a community. And I think if you have a cul-de-sac, putting a straight-through road is a major change in how that community functions and what the community has developed to be. Having kids go out into a cul-de-sac and play road hockey is so much different than having to worry about cars zipping down a straight lane. Now, this is just quickly, and like I say, I haven't talked to anybody in the community, but I'm not sure from the maps, is Fullerton or Fuller Road looking to be carried right through to Harris? No, that's not part of it. But if something like that was done, you could keep possibly the cul-de-sac and then have housing around the edges of the proposed property, and then have a ring road that's internal. Now, one thing that keeps the character of the Keith maybe cul-de-sac and community, it doesn't put a lot more pressure on Owen Street, and then it would also provide quick and easy access. Now, it's going to cost more money. There's going to be developers that are not keen on that, but it's just an idea that maybe we can consider heavily the concerns of the community, which from what I've heard is they don't want to lose that cul-de-sac and lose the character of that community and by having a road go straight through. So it's just an idea. The other question, has a traffic study been done? I'm not sure if, or is proposed to be done.
Mr. Verstegen, would you like to clarify on that, please? Has a traffic study been completed at this time?
Your worship, no, traffic study has not been. When we did the initial pre-consultation on this, the town engineering department did not require or did not request a traffic study for this. The focus was more the extension of Keith Maybe Boulevard down to Fuller.
Okay, thank you for the clarification.
Okay, well, thanks very much. It's just from transition to less waste, with the proposal or the idea that was presented, a traffic study may help provide good information as to whether that would be a viable idea or just either reassure or raise more concerns from the community. It would give us additional information. But anyways, I really appreciate the opportunity to just get some clarification and make some comments. And I'm glad that you're taking more time to consider this, and because it will have an important impact on a community. And I think, like our organization, is very supportive of established communities not having massive change that changes traffic patterns, safety. And I guess the other thing is Royal Roads, I think they have 2 portables already. So I would assume that that is, if that's one of the 3 schools considered, there are already, it seems they're maxed out in terms of their capacity. Like this would be a board issue, obviously. But there's also that further up on David Street, there's another development, which is, I think, at least 47. And if you just assume each household had 1 child, which maybe that's how it would average out, there is, that would be over 120 new students having to go somewhere. So I don't know if the board could have some input as to how they would handle that or not. But I appreciate the chance to ask some questions and make some comments, and thank you for your time, and thank you.
Excellent, thank you. Is there any further comments from the public who would like to speak to the application? Last call? Okay, seeing none. Thank you, everyone. Members of the council now have the opportunity to ask questions about the application. However, they may not offer any comments at this time. Questions from council? Councillor Hughes.
Thank you. This question is for Ron through the mayor. Has there been a previous subdivision submission for that land in regards to development of it?
Just so I understand the question through the chair, Councillor, you're saying on this parcel itself or on?
Yes, on this parcel itself.
Not to my understanding, no.
Okay, thank you.
Deputy Mayor Wilson, please.
Thank you, through you, Mayor. We've heard tonight there's some concerns that people were on the understanding that this would remain as a cul-de-sac. And I'm just wondering if staff had any insight into, history or previous plans that would help us clarify.
Mr. Graves.
I don't know if the CAO wanted to.
Yeah, I think we're going to go to Mr. Graves first.
Fair enough.
Sure you don't want Ron to answer?
You put your hand up first.
Yes, there was a subdivision agreement that was registered on title. It should have been registered for most of these properties, and it did identify the cul-de-sac as being temporary. That was something that was planned for some time. That's only our knowledge of it. That's the only knowledge that we have of the cul-de-sac.
Mr. Verstegen, would you like to add anything to that?
No, that was pretty much, Your Worship, what I was going to say as well.
Excellent. Further questions? Councillor Halliday, please.
Thank you, through you, Mayor. So to Michael's explanation, are you saying that this whole area with all these lots that have been kind of designed as cul-de-sacs are temporary, and that when these lots are being sold, the owners that are buying actually know that they're temporary?
Mr. Groat.
If I could through you, Mr. Chair. I can't speak to any other cul-de-sacs that are in the area, but this particular one was registered and identified specifically as a temporary cul-de-sac in the subdivision agreement, which would have been registered on title. I know is registered on some of the properties. I haven't searched all the properties. So that is whether I can't speak to what, when anyone purchased, what a realtor might have said. But the lawyer that conducted the sale should have identified the search on the property of the subdivision agreement that would have identified that as a temporary block.
Councillor Van Kooten-Bosens.
This is probably maybe through to Ron, through you, Mayor. The road going to Harris Street, I was under the impression when I looked at all the documents that it was going to be a road, but now I'm understanding that it is just a trail that is going down to Harris Street. Am I correct in that? Or is it a road that would only be available to the condominium portion of the development? Did you hear all of that, Ron?
I did, through the chair. So you're talking about that finger that extends from the parcel to Harris Street, correct?
Yes, down to Harris
Yeah.
Street.
Yeah, it's not my understanding. It's too narrow to be a public road or a road. I believe it's only about 8 meters wide. I believe the applicant has indicated that it would be for a trail for the condo block, if I'm not mistaken.
Mr. Graves would like to add to that.
Okay.
This time Ron took my words. Yes, that is not wide enough for a standard road, especially one that would come out onto a county road. It would need to be significantly wider. Any other properties in that area are owned by other owners and would need to be acquired in order to make a road wide enough. Not to mention there's some topography there that might be difficult to overcome, and the intersection at Harris Road would be a difficult one to attach into safely.
Councillor Halleran.
Question through your mayor, question for Ron. Is there a possibility that the Fuller Road is actually able to go through that property and be completed to Harris Street? Or is there something against that?
Through the chair, that's a good question. Just from a history perspective, I know that the county Public Works Department and the town's engineering department some time ago had investigated that, extending Fuller to Harris Street. But ultimately, the decision was to not, because A, there's the floodplain area in the area, there's the culvert that's located there as well that would make it a bit of a challenge to get a road connection to that point. And the other element too, that because of it's just a little bit south of the Canterbury Street, Harris Street intersection, it would make traffic movements in that intersection compounded in terms of what's already there because of the odd shape of how the road is configured, notwithstanding also that it's also the entrance pretty much opposite of where to the Cheese Museum as well and to the park. So I think ultimately that was some time ago that both Public Works at the county and the town engineering department indicated that they would not pursue that.
I have a question to the applicant. It does say on the trail, on the figure 7, that says trail easement over private condominium road. Is it your intent just to provide an easement for public to use that trail as well as the condominium road, or would that be just for those users?
Through you, Mr. Mayor. The intent was for the condo users to use it. Some of the concerns with the public is related to insurance and maintenance that the condo owners would take in. That said, I think it's something that if that was an important pedestrian connection, then we could take that away and explore it a bit further and how we could incorporate that into a condo development.
Thank you. I have a further question around parking with the private road. the width of the private road, how do we ensure, obviously the town would not have control over that. That would be a private road with the condominium corporation. What is it the standard, would that be the standard width of a town road, or would it be a narrower design? Or is that to be completed at a different time?
Through you, Mr. Mayor. Yeah, we haven't done detailed design at this time, but the concept shown pretty much aligns with what a private road would be. And it would ultimately be entirely owned and maintained by the condo corp. We have met all the zoning requirements for parking. So we've got some additional visitor parking areas specific for the cluster townhouse development. But yeah, the road itself would be built to private road standards.
While you're there, what would be the requirements, what are the requirements for the townhouses and the street towns?
Perhaps Ron, blanking me at the moment, maybe Ron can provide some input.
Ron, would you be able to provide that information on what the parking requirements are for each unit?
I believe the parking requirements, Your Worship, are 1.5 spaces per dwelling unit.
Okay. Just to clarify, because I know there's some concern, how do you quantify half a parking space?
Well,
Would that round up or down?
You round up, Your Worship.
Okay, so it would turn into 2 parking spaces?
That's correct, yeah.
Okay, thank you.
And then also, sorry, if I could also add that the bylaw also requires visitor parking to be provided as part of the development as well. And that's, the number of spaces are contingent upon the number of dwelling units that are proposed. I forget what the ratio is right now, but the condo development would require visitor parking as well.
Perfect, thank you. Councilor Van Kootenbos and then Councilor Halleru, please.
I have a follow-up to one of your questions, Mayor Petrie, and that is the trail easement over the condo road. Would there be enough room for a fire truck, ambulance to all get down in there in that respect? I'm assuming that there would be no parking at all allowed on the road, on that road, but would there be enough room for that to get down in there?
Through you, Mr. Mayor. So I would say that would probably be part of a site plan application, getting into a bit of the details in terms of like truck movements and exactly how things would rotate. We haven't specified exactly where all those elements would be, so it would just be a condo block. And then through that, we would develop it. Essentially, we would have to meet more standards if we were to create it public versus private. So that's something we'd have to take back and look into some of the details.
Councilor Halleru, please.
All right, this question through you, Mayor, is to the developer. I'm very concerned that there is a lot of land that is being developed on the side of Keith McGee, which is just a short portion of that street, the cul-de-sac ending there, and those homes being more low density. Is there a possibility that this is an opportunity to create a small community on its own? We've seen developments like this, whether it's tall condo buildings where you can kind of loop around and take advantage of like the existing exit and have that another advantage for fire or, police to come through and just circle around. Everybody has access to them without it adding additional strain on low density streets that are already dealing with that kind of, privacy. So I wonder if the developer can maintain what they want to do, but just have more of a ring road going through since you have additional parking, which means you don't really need to introduce that into the neighboring streets.
Thanks for the question. Through you, Mr. Mayor. I think part of that question might have to go back to Public Works. Our intent was always to have that through connection, and that was for safety and access and egress. Once you loop it, you have more residents on one road. So I don't know if Oshawa County per se has an exact number. I know places like Waterloo Region will have 26, where any more units than that, you need a second access for fire emergency purposes. So I think that would be a big consideration in terms of making sure that cars could get through should there be an accident or something that would require an additional access.
Deputy Mayor Wilson, please.
Thank you, Mayor, through you, to staff. We've heard a concern of high density from the community, but information from planning. So I just want to confirm that what's presented here is considered low density according to the official plan, or, maybe just going back and confirming that I'm on the same page as what's in the official plan and what's been presented today.
Your worship, yeah, the forms of development, I believe, as I've indicated earlier, are referenced in the planning report. Basically, low-density development can make up a variety of housing forms, including singles, semis, townhouses, and cluster development. So in this particular case, yes, the form of housing is considered to be low density. There is also the density range that I referenced earlier as well. So 30 units per hectare is the high end, and 15 units per hectare is the low end. So anything that falls within that range between 15 to 30 is considered to be low density residential. There is other elements too that say no units can be, or no dwelling units can be higher than 3 stories. And my understanding is here is, I believe 2 stories is what they're proposing.
Oh, it looks like Ron has frozen for a second. We will give him a second to compose himself. Mr. Graves, would you like to finish that statement?
Sure. Ron may have just done this to put me on the spot. So, yeah, I think what Ron's trying to say is that is the range. This does qualify as low housing residential, although it just meets that threshold.
Proposing here, just to confirm, these would be considered low density back.
Excellent. Yep.
So through you, just to follow up to the applicant then, is that how the applicant arrived at this number of units, that it puts you at the threshold of low density, or is this what makes the plan financially viable? I'm just, trying to understand the number of units from the applicant's perspective.
Through you, Mr. Mayor. I might let Paul speak to some of it in terms of, the overall vision, but I think the intent also is to provide a bit of diversity of housing. And to the previous comment, well, we're not providing affordable housing with that threshold. By providing some diversity of housing, you're providing various options, and we're able to efficiently use the site, and have elements of a condo corporation that would otherwise be maintained by the municipality. So I don't know if you want to add anything. Okay, all right.
Excellent. Any further questions? Councillor Hughes?
Thank you. I'm not sure if this one needs to go to the developer or to Ron. The one presenter earlier, and I'm sorry, I can't remember your name, I apologize, but she did mention the water wellhead protection area, which covers approximately a third of that land. How is that being dealt with, and have we actually, or has the planning department looked into that aspect?
Excellent. And Mr. Verstegen?
Sure, I can probably speak to that. So as part of the process under the source water protection plan, any applications that fall within the source protection area need to get a Section 59 clearance before any application can be circulated or even considered complete for circulation. So one of the first steps when before we could consider the application and circulate it, we directed the applicant to get a Section 59 approval from the county's risk management official, which they did do so. That then, once that screening is submitted or approved by the county's RMO, then that enables us to then circulate the application. So my short and long-winded explanation is yes, they have obtained approval.
Excellent. Any further questions? Seeing none. If there are no further questions, comments or questions, and the public meeting for this application is concluded. The application will now be scheduled to come before council at a subsequent meeting during which the planner's report and recommendation will be considered. And then I will ask for Councillor Van Kootenbossens. I believe you have a motion to accept the planner's report as information.
I do. Thank you very much, Mr. Mayor. Moved by myself, Councillor Van Kootenbossens, and seconded by Deputy Mayor Wilson, that the Council of the Corporation of the Town of Ingersoll receive Planner's Report number CP 2023-58 as information, and that we request a traffic study to be done by the developer prior to consideration.
Discussion. Councillor Hughes.
Yeah, definitely, I wouldn't want to see this go any further without a traffic study being done, because as we know, 85 townhomes could result in 85 more vehicles, which will definitely increase a lot of movement throughout that area, which, as was stated earlier, that intersection at Harris and David will definitely become considerably busier. But yeah, with that, I would definitely support, I would definitely support it with having that traffic study done.
Further discussion? Councillor Halleran.
Through you, Mayor. So I definitely agree with the traffic study for sure. And my recommendation is going forward, because there's so many other lots in the area, we have to be careful to set precedents where there's a general acceptable density in zoning, and then because we know we do need affordable housing, we do need diversity of housing, we get kind of caught up in this, we need housing, and so it doesn't really matter. We have areas in the community that we will be able to just start off scratch and do as much as we want, but when it comes to existing communities, I think we really have to exercise caution in what kind of precedents we're
Sorry, I'm
setting.
just going to caution because we cannot make comment on an application until time
All
is
right.
being presented, okay? Sorry.
All right.
Unless we want to speak to the actual motion. Is there any further discussion on the motion? Okay, I will comment that I am in favor of the traffic study, as I hear there has been concerns about traffic and how it affect the development, and seeing how our engineering department director is not with the town at this time, so they're not here to able to justify their decision. I think that is, I think it is within good consideration to have that information going forward before such decisions are made. So I would support this motion. Any further discussion? All those in favor? Opposed? That is carried. As a reminder, if any member of the audience wishes to be notified of the decision of council of the town of Ingersoll in respect of any zoning bylaw amendments, they must submit a written request to town clerk Danielle Richard at danielle.richard@ingersoll.ca. The clerk must provide notice of council decisions to all those who request a copy within 15 days after the day the bylaw is passed. Anyone may appeal the decision to the OLT while filing with the clerk within 20 days of the notice of decision. The notice of appeal must set out the objection to the bylaw and the reasons in support of the objection, accompanied by the required fee. If there are no further comments of the question, I now declare these public meetings to be closed. Seeing none, they are closed. I will now ask for a 5-minute recess. Moved by Councillor Van Kootenbossens, second by Deputy Mayor Wilson. All those in favor? Opposed? Carried. Thank you. Excellent. Council will now come back to order, and we will proceed now. I will just remind, if you're going to have conversations, please exit all the way down to the end of the hallway. And now we will have a delegation from Dennisburg regarding indoor pickleball courts. Dennis.
Good evening. Pickleball, the fastest growing sport in North America for all ages. Good evening, Mayor, councilors, clerks, and other attendees. I'd like to congratulate all of you newly elected councilors and our new mayor. I believe that change is always required for new and fresh ideas. My name is Dennis Burt, and I live in Woodhatch here in Ingersoll. I would like to thank the village for your efforts in getting at least 2 new pickleball courts constructed here in Ingersoll at the Senior Center. Your efforts have been well appreciated by several local citizens that I have been in contact over the last few months. My only recommendation with the project would be put in at least 3 outdoor pickleball courts, or possibly 4 at this location, as you can put 2 pickleball courts on 1 tennis court. They currently have 2 tennis courts at the location in question. I've been there and looked at it. I currently play pickleball. I know of several local citizens that live here in Ingersoll that either are playing or they are interested in learning the sport. My wife and myself are both willing to volunteer our time to assist in teaching any new beginners the rules, techniques, equipment required. Hopefully some of the faces I see here today will be interested. I also know of others that say they would also assist in teaching this amazing game. As I have stated before, this is the fastest growing sport in North America. My wife and myself have been playing for over 10 years, and I've played in over 30 pickleball venues throughout Ontario and the USA. Yes, my wife is actually better than myself, but now I'll never admit it. I've gathered over 40 Ingersoll residents' names to date of those interested in playing pickleball here in Ingersoll. Once you open up the outdoor and possible indoor courts, there'll be many others joining immediately. Outdoor courts are only good for around 5-6 months of the year, weather permitting. Indoor pickleball courts required for year-round play. My wife and I currently travel to Dorchester Community Center 3 times a week, year-round. We also venture to Woodstock, Thorndale, St. Mary's, and London to play. Other players from Ingersoll also inform me about traveling to other communities. Here's my proposal to you for consideration. I'm proposing to create available indoor pickleball courts located here in the village of Ingersoll. These are the local locations: the Downtown Arena Banquet Hall, the CAMI Building at the Senior Center, local public school or high schools, or any of the facilities that I have missed that may be suitable. I've already attended the Fusion Center, as they already have a pickleball court where they set up a mobile net in the gym. I've already had a meeting with Craig Bodie, the Fusion manager, and myself and my wife volunteered to teach him and the staff the rules and techniques of the game. Excuse me. There will be in return, he'll be teaching the youth of today to play pickleball. Craig has taken me up on this offer. I'm now waiting for an agreed upon date and time. Unfortunately, they only have 1 pickleball court in their gym, which is not suitable for our proposal. The cost to set up these above venues in question to accommodate pickleball courts will be minimal without any major construction or changes to the facilities. And any of these facilities do not have lines that need to be added. Mobile nets can be purchased, assembled, and taken down after play. Costs for players will be done on a daily, weekly, monthly, or yearly memberships. The school locations that I've suggested would have limited time frames, but the other locations could be more flexible. When my wife and myself lived in St. Catharines, I approached the mayor with the same proposal that I am submitting to you at this time. The mayor set up with me to work with the local recreation department. We arranged to have evening play at a local high school for 2 evenings a week. The school had 3 badminton courts with lines that works well for pickleball. The city purchased 3 mobile nets and they supplied the balls. I believe the current Ingersoll Village Arena Banquet Hall would be the best option as it sells them used in the day and they also accommodate some evening weekend hours. I assume you could get at least 2 or possibly 3 courts in that facility. I was informed that the KME plant was on the senior center was offered to the village, but the village turned it down. They could also be a great option if suitable, as all the pickleball courts would be in the same location. The new Ingersoll Community Center Gymnasium plan for pickleball courts is a long time from being reality at this time. I was informed by someone on the planning committee that the Phase 1 ice pad will be built first, whenever, and the Phase 2 gymnasium will be built once they get financial support for that project, who knows when. I am willing to work with any one of the councilors or Parks Recreation staff to help make my proposal reality. Keeping the local citizens playing here in town would definitely support our local business community, as now players are traveling out of town will have a tendency to spend their money in those communities. Maybe our local business community would also be interested in supporting our cause for indoor pickleball. The other great benefit is keeping our locals active, mentally and physically. Keeping track of the scorer, who is serving, and where to be on the court definitely helps seniors mentally. We really noticed a decline in our citizens during the not too long ago COVID pandemic. Who knows if and when it may happen again. If you have any questions or concerns, I'm open for any type of dialogue. My motto is, if there's a will, there will be a way. Thank you for your time. Respectfully, Dennis Burt.
Thank you very much, Dennis. Is there any questions from council of the delegation? Councilor Hughes.
Through you, Mayor. Dennis, have you actually reached out to the Thames Valley School Board to see if they were interested in allowing you guys to set up in the gymnasiums around town?
No, I have not. And the reason for that, when I was in St. Catharines, they sent me to the rec department. They already had programs running in the schools. I didn't know if council here did that, or I know my tax money goes to, so who is overall responsible to look after that? So that is not something I'm aware of. I have no problem doing that if that's suggested. So,
Mr. Graves.
Yeah, the municipality has been pursuing a reciprocal agreement with the school board for several years, and we have had great difficulty getting them to enter an agreement to allow us to utilize those spaces, although they tell us at many occasions, including a very recent meeting that we had with the school board, that we are allowed to do that, and they would like to encourage that. In the meeting that we were in very recently, several politicians expressed their frustration, saying it is very nice of you, school board, to tell us that that is the case, but we have difficulty seeming to finalize these agreements. Having given the most recent meeting, I think both the mayor and I are of the same opinion that we will be actively pursuing those agreements and trying to complete that ability for our community to utilize those facilities, because they're great facilities that can be utilized for this and many other uses without recreating other spaces by the municipality. And it is the school board's mandate that these be allowed to be used by the community.
question on that, has you been to the school? Anybody been to the school that knows that they've got badminton courts already lined up? Oh, they have? So all you need is these mobile nets and balls, and away you go. And that'll keep some of the residents,
Councilor Halleru.
Yeah, just to add to that, I'm aware that it may be difficult to have the agreement to use the facility, but on an individual basis as a nonprofit or a club, you can actually directly on their website apply to use these facilities. And I think that's the difficulty we're having when the town wants to organize it and they rather do it on an individual basis. So as long as they keep trying to fight for that collective agreement, I think you can definitely take a look at what they have to offer on their website. There's pricings, there's locations, and we can maybe get off that way.
Just to let you know, when I was in St. Catharines, what they did, they had a volunteer, because some of the schools have volunteers for these kids that go to school. their volunteer hours were part of setting up, collecting money, and running that time. And you're sort of putting two in the same boat, really, that you're helping out the community, you're helping out, you know, local kids.
Well, thank you much. Thank you very much. I do. I encourage you to stay in touch with town staff as well to make sure that they're aware of what we're trying to do, or you're trying to do as well, so that if there is opportunities available, they can be made to you.
And is there someone I can approach? Is there, or do I just go to the?
Mr. Graves is our CAO, and he'd be happy to help you.
Oh, I appreciate that. Thank you.
Yep. Excellent. Thank you so much.
Thank you very much.
Excellent. Do we, Deputy Mayor Wilson, you have a resolution, please.
Moved by myself, seconded by Councillor Bowman, that Council of the Corporation of the Town of Ingersoll receive the delegation from Dennis Burt regarding indoor pickleball courts as information.
Sorry, next we will go back up to item 11 on the agenda, Zone Change Application Planner Supplementary Report, number 7 CP 2023-10 ZN 6-2208, 160 Carnegie Street. Mr. Verstegen, would you like to present your report, please?
Yes, thank you, Your Worship. This is a supplementary report that was prepared for the zone change application that is on 160 Carnegie Street. In particular, the applicant is seeking to amend the zoning, the existing MR zoning, to allow for a standalone business office within the existing building. The lands, as shown in the planning report, are on the south side of Carnegie Street between Pemberton and Mutual Street. Lands are designated for industrial purposes and have a current restricted industrial zoning on the property. And in particular, the applicant is seeking to allow for business offices within the existing building, being approximately 462 square meters, or just under 5,000 square feet. In terms of the application, we feel the application is generally consistent with provincial policy. The OP policies do permit industrial uses as the primary use. They do allow business offices as a permitted use which are accessory to industrial use. Policies also speak to allowing for a limited amount of commercial uses. Now, given the existing uses in the immediate area, and in particular being the residential lands on the north side of Carnegie Street, there is transitional policies in the county official plan that do speak to, where we have some of these established industrial areas that are in close proximity to existing residential. We're acknowledging that they experience pressure to redevelop for other uses that may be more compatible with adjacent land uses. The policies also say the council may consider the reuse or redevelopment of these existing industrial buildings and sites through a site-specific zoning for limited service commercial types of development. Ultimately, however, when it comes to these type of applications, and in particular business or professional offices, typically how we've interpreted is that these type of uses should be limited to the downtown core to ensure that the core area of the town maintains its planned function as a focus for business activities within the town. And it's really kind of from a commercial hierarchy's perspective, the town's core area is really kind of the focus for commercial business activity. Now, this also is in keeping with provincial policy, which speak to enhancing the vitality and the viability of your downtown cores. This position, there is a negative recommendation based on this because we feel that these types of uses should be located in the downtown core and not allowed to migrate outside of your core area. This position is also supported by the town's manager of economic development. Now, it's an acknowledgement too, again, that there is transitional policies. So if council were to consider approval, there is options available for council's consideration to distinguish this type of proposal from the other business professional offices. And what I'm talking about here is establishing a minimum size for a business office space, which is not typically provided in the downtown core. So that's really the extent of my presentation, Mr. Chair, or sorry, Your Worship, subject to any questions from council.
Excellent, thank you very much. I believe before we have questions from council on the planner's report, I will like to move to the next and have the delegation from Mark and Ethan Williams, if that's possible. Thank you.
Thank you very much. Thank you for your time. Mr. Verstegen was stealing part of my presentation there, that you guys actually have the power to make this so, to kind of take a look at the area and acknowledge that maybe it's not the best use. First of all, just introduce Ethan Williams on Zoom. We have Ms. Stark. She was a town planner for the city of Toronto. She's actually helping us with the application. Also mentioned here was Roy Bereowsky. He's a lifelong friend of mine. You okay? Sure. And he wasn't able to attend tonight. He got stranded in the snowstorm down south, so I don't feel too sorry for him, but so I'll try to get through this. I know you want to keep it to 10 minutes. I'll kind of refer to my notes to keep myself organized here. First of all, I want to thank the town staff too and administration. I called on them, sent them lots of emails, so thank you for putting up with me. Mr. Verstegen also, he was very helpful and made me understand the process. First of all, to start off, if you follow the agenda, I just want to kind of clarify a few things. The town report was referred to as a conversion that we're going through. We're not asking a conversion. That would imply taking something away. We are asking for an additional use to the building. The town report also mentioned 3 offices. It actually just sounded like there was going to be 3 different businesses there. It's actually one business office with 3 different rooms referred to as an office. So I think there's just a little confusion. Also in the town report, it referred to the previous owner having connection to a contractor shop. That wasn't the case. If you look in tab 4 of your report, we have a notice from the previous owners that they operated for over 11 years as strictly a business office. So to jump in, there was really 4 main concerns that came from the town report. The first one, referred to business. There's buildings downtown suitable for professional offices. Initially, when I read that, I think I misunderstood it. It's not saying that it's suitable for us. It's just saying there are buildings that are suitable for professional offices. We're looking for like some very specific size, parking, some other criteria that just isn't found downtown core. We did a survey of the downtown core. Tab 10 of your presentation would have the outline of what we were looking for, and that there is just nothing downtown that meets those needs. Another concern was the potential to weaken the downtown core. Right now I'm actually working out of a Bank of Montreal building. Bank of Montreal is not leaving. It's still there. We're allowing more capacity within that building. We're actually expanding. Part of what I need to do is actually hire some more people, and there's just no room in the building. So, by, supporting our application, or actually supporting my business to grow. The other, Walker Environmental was there for like 11 plus years, and there's no evidence of them having a business office there hurting the downtown core in any way. And I also believe that just growth in your outside your downtown core brings more people to your town, which they go downtown to do stuff. With respect to Walker, another large office building in town's Earth, those people are downtown eating dinner and, eating lunch, getting haircuts. So it does support the town core. The number C I addressed further above, that we are not asking for the removal of any use in the area. Undesirable precedent was mentioned in the planner's report. You know, there's just no other building that's this size, this makeup in a residential area. I just don't know where the precedent would be. You'd have to issue a building permit for that building to be built here. It just doesn't exist. So I think it's tough to actually press for a precedent. Undesirable, I think it's just an opinion. I think that if we go on to the comments in the area, this is, you know, the official plan was done 27 years ago. If you look at your map.
Just 1 second. Sorry, sir. Sorry, we have to have the doors open. Yeah, sorry. Continue.
If you look at the tab 3, where there's a map of the town, or sorry, of this area, you will see that, you know, there's a lot of green space there. It is underdeveloped. And part of that might be that some, like industrial use buildings, or people have gone there and just said that they don't want to build across the street from residential. They'll know there'll be problems down the road. You know, under the official plan, which that's really getting to Jenny Stark online there, getting onto more of her experience or her expertise. There is like sections in the official plan that states that you should be using land, particularly vacant land, efficiently. You know, over the 27 years that residential area has grown across the street, and, you know, I think there's the larger question of whether this industrial, MR industrial, is actually suitable now, or whether the whole area should be looked at. That's a bigger picture. We're not asking for that. We're just really looking for something specific to our building. You know, in the report, you know, comments on the building, no one actually stated any concerns about this building actually being used for a business office. There's ample parking. The building's actually designed for it. There was no concerns about that. And really, you know, I think in a nutshell, you know, this is like a very small change. You can have a business connected to an industrial use and have a business with an industrial use in there, separate, and the functionality of the building is exactly the same. Like, nothing changes, right? You know, the only way you could actually probably tell from the outside is if there was some signage, right? Everything else, it might have actually been able to be covered off as a minor variance, as I've been told, right? Again, that's not my area, that's somebody else's area, and Jenny can come on and talk to that in a moment. Another thing when looking at the provincial policy and the official plans, you know, like this is the first time I've read this type of stuff. It's actually quite broad. It's really, the official plan is really support economic growth, support employment growth. A lot of the provincial policy, when referring to the downtown core, it really seemed to be referring to retail, you know, nightlife, that type of stuff, which I'd say more is kind of restaurants, residential. So, you know, I think you need a mix, and that is in the official plan. But I think you can have too many offices downtown, right? I think really if you had a full downtown core that was restaurants and retail, that would be fantastic. If you had a whole downtown core that was offices, that wouldn't be so good. So there's always going to be a bit of a tipping point. You've got banks, you've got credit unions, you have real estate offices already, you have accounting offices. You know, that's fine. I think you should be able to allow some larger offices outside the downtown core. If Jenny wants to pipe in here, is she on the Zoom? There we go. I'll just give her a moment just to give her comments. Hopefully she's still there. Wow.
Hi.
Oh, there you are. Great. Okay.
Here I am.
Yeah. Thanks, Janie. Yeah, just go ahead with any comments you have about the plan or your presentation that you gave within the package.
So I think you really just need to look at it as office uses are already contemplated, both by the bylaw, your official plan, so you already comply with all of the policy statements. Extending the use to a standalone business office doesn't change the policy. It doesn't offend any of the policies. We're not hurting the downtown core. We're not leaving vacant office spaces. We're leaving an office that's already existing and moving out. There's no space in the downtown core that can accommodate an office of this size. You're looking at economic growth. You're looking at a building that if we don't extend some of the uses permitted in there, you might be looking at more vacancies. You already have a lot of vacant space on that street, underdeveloped, underutilized. We're not asking to remove any of the industrial provisions, so we're not taking away any provisions for future growth. You're just asking for a standalone business office as an additional use. And I think that all your policies are maintained while allowing an additional use to be added.
Okay. Thank you. So I think I'm within my 10 minutes. I'll just make some quick closing remarks and then open it up for any questions or comments. So, you know, really, there's nothing available in the downtown core this size. Like, there's just nowhere I can go downtown. You know, it's not just size, but it's also other attributes of the building. You know, this is supportive of economic employment growth, which is core to any official plan. And I just don't believe it weakens the downtown core. There's been no evidence of that. Allows us to actually maximize the best use of the building also. And as Jenny mentioned, having a business office is an expectation within the current bylaw. It's just right now stated that it's connected. We're just asking it to be unconnected. It's a very small change. And also, as Mr. Verstegen, he was stealing my thunder there, I was going to point you to a section of the official plan in the town report. That would be under tab 7, page 3, that gives direction to the council. You know, specifically an industrial use area has residential area nearby, and how that you have to kind of adapt by site-specific zoning changes. That's exactly what we're recommending here. Okay, so do you have any questions or comments? Whatever your procedure is here.
Yeah, thank you for the presentation.
Okay.
Are there any questions of clarification from council of the presentations? Seeing none, thank you very much.
Okay, thank you.
Thank you, Mr. Verstegen. I will first ask Council, Councilor Hallery, do you have a motion to accept the delegation for the presentation, please?
Yes, I do. Thank you, through you, Mayor. That it's moved by myself, Councillor Hallery, seconded by Councillor Hudson, that the Council of the Corporation of the Town of Ingersoll receive the presentation from Ethan Williams, Mark Williams, Jennifer Williams, Roy Bereowsky, and Jenny Stark regarding 160 Carnegie Street as information.
Discussion. All those in favor? Opposed? That is carried. Excellent. We'll now consider the application. Councilor Hughes, would you like to make a motion at this time, or would you like to have further actually, yes, I would like to make a motion, and we can discuss that motion, please.
Okay, so I have two options here, and I'm going to pick option 2, moved by myself, Councillor Hughes, seconded by Councillor Hallery, that the Council of the Corporation of Town of Ingersoll approve in principle the zone change application submitted by Ethan Williams, whereby the lands described as Lot 19 and 20, Plan 279, being municipally known as 160 Carnegie Street, Town of Ingersoll, are to be rezoned from restricted industrial zone MR to special restricted zone MRP, to add business or professional office to the list of permitted uses with minimum ground floor area of however many feet we want to discuss. Square feet. Want me to put a number in?
Yes.
4,500 square feet.
Councilor Hallery, you're good to second that still?
Yes, sir. Through you, moved by myself, Council.
No, I
Sorry.
just wanted to make sure, since he's added addition, that you're still good to second that.
Yes. Yes, I'm seconding in the motion.
Okay. I'm going to first turn the floor over to Mr. Graves before discussion, please.
Thank you. Through you as the chair. This application I know has been a difficult one, and I appreciate all of Ron's work. And I know that there's been some questions about receiving it. I appreciate that the applicants have gone to the great effort of getting a planning report done, and I appreciate the background that that gives. It is correct to state that the official plan does allow where areas abut, industrial areas abut existing residential areas, that town council can consider the reuse or redevelopment through site-specific zoning, and that's what's being requested here. I think the concern for staff is that we don't want to set a precedent. We very recently had an application in front of us about potential downtown uses outside of the downtown, in a more of a commercial plaza, less than, it was not really a industrial area abutting a residential area. So this differentiates that from that. But my suggestion to council would be to include some kind of a minimum square footage. My reasoning for that would be that it would differentiate it from a number of other properties. I think the applicant is being true when they're saying that we're trying to find properties in the downtown, but we can't find them of this size and scale. It would minimize the impact on the downtown. It would make sure that many properties, aren't sort of bleeding out. You get to this point in your downtown where you get requests to be outside of the downtown, but I think limiting in this way means that only properties of a size and scale that are this big would be outside of the downtown. So that, I think, minimizes the impact to the downtown, and it minimizes the precedent setting on a number of other areas. My suggestion would have only been about 4,000 square feet. I think that's enough to differentiate it from the other uses in the downtown core, and I think that's something that the applicant might be willing to accept. And I think that gives you enough to limit the precedent-setting requirements of this.
Thank you. Would the mover and second, would anybody like to make an amendment to the motion? Councillor Hughes?
Yeah, I'll make the amendment, dropping the square footage down from 45 to 4,000 square feet.
If we could pass this down so we can have that in writing, please. As we have all learned, there's no such thing as a friendly amendment. Our procedure bylaw does state that all amendments need to be in writing.
So I have to rewrite this whole thing. Perfect, yeah, give me.
No, just the amendment.
Just the amendment. Okay, perfect.
The ground floor area.
Yeah. To change. Ground floor area, minimum to 4,000 square feet.
Which is 372 meters square.
It's not the ground floor.
372
For
meters square.
372?
372.
Oh, 372 square meter or 4,000 square feet.
Seconded by me.
I'll have that down this way and we can discuss that. Okay, we have an amendment moved and seconded by Councillor Hughes, seconded by Councillor Halleru, that the Council Corporation Town of Ingersoll amend the motion to change ground floor area to
300.
4,000 square feet.
Yeah, 4,000 square feet.
Discussion? Councillor Hughes?
Yeah, I think this is a win-win-win scenario for us and the residents, and as well as the a company that owns and is looking to do this. Because other than that, you try to build an industrial plant or something down in that area, seems very counterproductive. The fact that they are expanding and don't have that available space in the downtown is definitely a benefit to have this availability to us, that where we can place it in town as opposed to having them going out of town where they can find this area.
Okay. Councillor Bowman?
Thank you, Mr. Mayor. I too will be supporting the applicant's request. Again, for a couple of different reasons. First of all, it's a historical use over the last few years. It has been used for this office type purpose in the past. Second of all, there isn't anything downtown that can facilitate the amount of square footage that he's looking for. I would rather, as a downtown merchant, I would rather see the business move to an establishment like this or a location like this rather than lose them and have them go out of town. I think it can only enhance what we've already got. And third, there was some concern, I think at the last meeting, about the residents across the street being residential.
Just to clarify, we're talking about the amendment at this point.
The amendment, okay, the amendment, yeah, okay, yeah.
There'll be further discussion on the...
Okay, very good, thanks.
Any further discussion on the amendment? Seeing none, all those in favor? Opposed? That is carried. We will now consider the amended motion Would anybody like the amended motion reread? Okay. Further discussion on the amended motion? Councillor Bowman, would you like to continue?
Thank you, Mr. Mayor. Now, I was just going to say that when we're looking at residential right across the street, I think this would be a better fit. I think we've already heard complaints before about industrial being right across from residential and some of the concerns it may cause. And I think this is just a better fit for that area. So again, I'm going to be supporting this.
Councillor Van Kooten-Bosens.
Thank you, Mr. Mayor. I want to thank you, Mark and Ethan, for coming forward and doing all the homework that you did. Jenny, it was a great report that you brought forward. I'm not usually one to go against our own planner, but you brought forward the reasons why we should be. And I'm really sorry, Ron, to go against you, but I'm very thankful to staff as well for working with you and getting this, as people have said, a win-win situation. I think it's a great thing. You will bring more business into our area. You're going to bring more business into the downtown area because I know you and you're one that supports our downtown, and I appreciate that. So thank you very much. I think that the support around the table will be evident, so thank you.
Further discussion? I will weigh on this. Without this minimum square foot, I would not be in favor of the application. I actually believe that it's more close to an official plan amendment than it is to a zoning change, as it goes against the official plan policies of the town and the county to have standalone office use within the industrial zone. I think that's important that we protect our downtown core as well as our industrial uses, and therefore I agree with staff's opinion on that. I do also recognize that there is a need, that there's not the ability to have the space that the applicant is looking for within the downtown core, and that's why I'm supportive of this amendment to have the gross floor area considered so that it can be thing. I certainly do not want a precedent setting, and I unfortunately agree that any decision that we make is precedent setting. An example is your own planner used past decisions as precedent setting cases towards approving this one. So certainly do not want to see other applications coming forward that will use the same arguments that may have detrimental effects to our downtown core. I do believe this will go to mitigate that, and that's so therefore I will be in favor of it. But failing that, I certainly would not be. Further discussion? All those in favor? Opposed? That is carried. Moving on, we will now go into committee of adjustment to consider planner's supplementary reports. I believe, Councillor Hudson, you have a motion, please, to take us to committee of the whole, or committee of adjustment, sorry.
Moved by myself, seconded by Councillor Van Kooten-Bossen, that the Council of the Corporation of the Town of Ingersoll adjourns the March 6, 2023 regular meeting of Council at 9:09 p.m. into a Committee of Adjustment meeting to consider the following minor variance applications. Number 1, A-01-23-347, King Street West, Ingersoll Machine and Tool Precision. Number 2, A-0422-286, Oxford Street, Tim and Andrea LeBlanc.
Discussion. All those in favor? Opposed? That is carried. Take this off because we're now in committee of adjustment. Excellent. Minor variance application number 1, A-01-23-286, Oxford Street, Ingersoll Machine and Tool Precision. Has the secretary of the committee received any additional correspondence on the application that is not noted on the agenda?
I have not.
I need to start again because I did not have my microphone on, and no one at home could hear me, and I apologize for that. So we are now going to deal with minor variance application number 1A-01-23-286, Oxford Street, Ingersoll Machine and Tool Precision. Has the secretary of the committee received any additional correspondence on the application that is not noted on the agenda?
I have not.
Excellent. I now ask the applicant if they have any further comments to make. Actually, I'm just going to now ask planner Ron Verstegen to overview the planning report, please.
Thank you, Mr. Chairman. First application for committee's consideration is the variance to enable an expansion to the existing facility on the IMT property. They've requested 4 variances that are detailed in the planning report, from reduced setback from the exterior side yard along Ingersoll Street, increased building height for the portion of the building, and also reduced setback from the center line of Ingersoll Street, and then finally reduction in the parking requirements. Through the circulation of the application, comments came back were in support of the application. In particular, the fire chief for the town, the chief building official, and also County Public Works. And these are relevant to consider County Public Works because of its Ingersoll Street as a county road. As mentioned, no comments have been received with respect to the application. So very quickly, in our opinion, the application is consistent with the official plan policies, generally consistent with the zoning on the property, represents desirable development of the property, and also the variances, even though there's 4 of them, we feel they are minor in nature. So therefore, it meets the 4 tests of the minor variance. And there is a recommendation to support the application, Mr. Chairman, and just also for the committee's consideration too, that there is another step that the application, this development will go through, and that's through the site plan amendment process, where issues like grading and servicing and drainage will be addressed. So anyway, subject to any questions from the committee, that's the extent of my presentation.
Thank you, Mr. Verstegen. Do any of the committee members have any questions for Mr. Verstegen's report? Seeing none. Member Van Kooten-Bossens, I believe you have a motion for this application.
I do, Mr. Chairman. I will go ahead and read that. Moved by myself, member Van Kooten-Bossens, and seconded by member Wilson, that the Town of Ingersoll Committee of Adjustment approve application file A-01-23 submitted by Ingersoll Machine and Tool Precision for the lands described as part lots 143, 144, 145, 146, and 147, Block 27, Plan 279, municipally known as 347 King Street West in the town of Ingersoll, as it relates to 1, relief from the provisions of section 14.2 zone provisions exterior side yard minimum width to reduce the minimum required exterior side yard width from 15 meters or 49.2 feet to 11.5 meters, 37.7 feet. 2, relief from the provisions of section 14.2 zone provisions building height to increase the maximum building height from 15 meters, 49.2 feet to 18 meters, 59 feet. 3, relief from the provisions of section 14.2 zone provision setback from the center line of an arterial road to reduce the minimum required setback from 29 meters or 95.1 feet to 24 meters or 78.7 feet. And 4, relief from the provisions of section 5.19.2, table 5.19.2.1 parking standards to reduce the required parking from 253 spaces to 184 spaces to accommodate an addition to an existing industrial facility comprising approximately 7,570 meters squared or 81,482.8 feet squared on the subject property, subject to the following condition. One, that the building be constructed at a location as generally shown on Plate 3, and that the building be configured as generally shown on Plate 4 of Planning Report 2023-60 to the satisfaction of the Town of Ingersoll. The proposed relief meets the 4 tests of a minor variance as set out in Section 45(1) of the Planning Act as described in Planner's Report CP 2023-60.
Thank you, Member Van Kooten-Bossens. Discussion. Seeing none. All those in favor? Opposed? That is carried. Application A-01-23 has been carried. If any members of the audience wishes to be notified of the decision of the Committee of Adjustment for the Town of Ingersoll in respect of the minor variance, please submit a written or email request to the Secretary of the Committee of Adjustment, Daniel Richard, at daniel.richard@ingersoll.ca. The Secretary must provide notice of the Committee's decision to all those who request a copy within 10 days after the making of the decision. Only the applicant, the minister, specified persons, i.e. various public utilities or public bodies, may appeal decisions in respect of applications for minor variance to the Ontario Land Tribunal by filing with the Secretary within 20 days of the notice of the decision. The notice of the appeal must set out the objection to the decision and the reasons in support of the objection, accompanied by the required fee. We will now move on to minor variance application number 2, OA-04-22-286 Oxford Street, Tim and Andrea LeBlanc. The application, has the Secretary of the Committee received any further correspondence on the application that is not noted on the agenda?
I have not.
Excellent. I now request the planner, Ron Verstegen, to overview the planning report, please.
Thank you, Mr. Chairman. Last application for the committee's consideration is, as mentioned, the property that's on Oxford Street in the town. In particular, the applicant is seeking to building addition onto an existing accessory building on the subject property, which would exceed the bylaws current cap of 100 square meters. In particular, the applicant is seeking to increase this requirement to 129 square meters for the newly configured structure. Agency comments are supportive. They are reflected in the planning report. Comments came back supportive of the application, including the town's chief building official. As mentioned, no comments have been received from neighboring landowners through the circulation of the application. In our opinion, the application meets the 4 tests of a minor variance. No impacts are anticipated on neighboring properties because realistically, the property itself is fairly large. So really, it only represents the structure about approximate 6.9% amount of lot coverage on the property. So it's fairly minor in nature. Based on this, Mr. Chairman, there is a recommendation to approve the application.
Excellent. Is there any questions for Mr. Verstegen? Councillor Hughes.
Thank you. Through you, Chair. So I'm just looking at the overview, satellite view of the property. It shows there's an extra building that is also maybe a garage or whatever it is. Is this new addition going to be added to the existing garage?
Through the chair, that's correct. Yeah, it is an addition to that existing detached garage.
Okay, thank you.
Any further questions from the committee? Seeing none, I'll call on Member Wilson for a motion, please.
Moved by myself, seconded by Member Bowman, that the Town of Ingersoll Committee of Adjustment approve application file A-04-22 submitted by Tim and Andrea LeBlanc and Megan Flinsenberg for the lands described as Part Lot 157, Block 29, Plan 279, municipally known as 286 Oxford Street in the Town of Ingersoll as it relates to 1. Relief from the provisions of Section 5.1, Accessory Uses, Buildings and Structures, Table 5.1.1.4, to increase the maximum gross floor area of a building accessory to a residential use from 100 meters squared or 1,076 feet squared to 130 meters squared or 1,400 feet squared, to permit an approximately 75.8 meters squared or 816 feet squared, addition to an existing 53.5 meters squared, or 576 feet squared, accessory building. The proposed relief meets the four tests of a minor variance as set out in Section 45(1) of the Planning Act and as described in Planner's Report CP 2023-59.
Thank you, Member Wilson. Any discussion? All those in favor? Opposed? That is carried. Application A-04-22 has been carried. If any member of the audience wishes to be notified of the decision of the Committee of Adjustment for the Town of Ingersoll in respect of the minor variance, please submit a written or emailed request to the Secretary of the Committee of Adjustment, Daniel Richard, at daniel.richard@ingersoll.ca. The Secretary must provide notice of the Committee's decision to all those who request a copy within 10 days after the making of the decision. Only the applicant, the minister, specified persons, i.e. various public utilities or public bodies, may appeal decisions in respect of applications for minor variance to the Ontario Land Tribunal by filing with the Secretary within 20 days of the notice of decision. The notice of appeal must set out the objection to the decision and the reasons in support of the objection, accompanied by the requiring fee. If there are no further comments or questions, then I will call for adjournment. Councillor Bowman, I believe you have a motion, or sorry, Member Bowman, you have a motion, please.
Yes, I do, Mr. Chair. Moved by myself, that the, seconded by Councillor Use, or Member Use, that the Committee of Adjustment meeting for applications A-01-23 and A-04-22 be hereby closed.
Discussion? All those in favor? Opposed? That is carried. Councillor Use, do you have a motion to bring the meeting back to order, please?
Sorry for the delay. Moved by myself, Councillor Yu, seconded by Councillor Hallerou, that the March 6, 2023 regular meeting of council come back into order.
Discussion? All those in favor? Opposed? That is carried. Will council like to consider a 5-minute recess? Councillor Van Kootenbossen's moved. Councillor Yu seconded. All those in favor? Opposed? That is carried. We will reconvene at 9:30, please. Okay. Okay, excellent. We can now return to our regularly scheduled program. Councillor Van Kootenbosens, do you have a motion to, for the consent agenda, please?
Thank you, Mr. Mayor. Moved by myself, seconded by Deputy Mayor Wilson, that the items contained in the March 6, 2023 consent agenda be adopted as presented.
Discussion. All in favor? Opposed? That is carried. Deputy Mayor Wilson, motion to receive the minutes from February 13th, please.
Moved by myself, seconded by Councillor Bowman, that the minutes from the February 13th, 2023 regular meeting of council be adopted as presented.
Discussion. All in favor? Opposed? That is carried. And Councillor Bowman, minutes from February 16th, please.
Mr. Mayor, moved by myself, Councillor Bowman, seconded by Councillor Youth, that the minutes from the February 16th, 2023 special meeting of council be adopted as presented.
Discussion. All those in favor? Opposed? That is carried. Next, we are going down to special reports. Number one, plant more trees. Mr. Grace, please.
Thank you. I've made a few notes as the evening's getting late, and I want to make sure I don't forget to say certain things, so I apologize if this sounds a little too red. I'll try not to do it in a monotone voice. It was a dark and stormy night. Sorry, this report is driven by the goal in the strategic plan identified as plant more trees. The report establishes a prorated goal based on the federal goal to plant 2 billion trees, being approximately 4,000 trees to be planted in Ingersoll by 2030. This goal will be accomplished by utilizing a few different methods. If council adopts this report, staff will meet with several groups and agencies, including the Upper Thames River Conservation Authority and Transition to Less Waste, to determine where trees will be planted and what type and what size of trees will be planted. An update to the tree canopy bylaw will then come forward after those discussions. In the meantime, if this report is adopted tonight, developers will be advised that any trees that they may cut down for development purposes will need to be replaced with 3 trees at minimum.
Questions of the report from council? Deputy Mayor Wilson, please.
I know everyone's excited about the tree policy, so it's exciting to see it coming forward. In looking at what other municipalities have done and just recognizing the ecological services that a tree provides and not just the aesthetic purpose, other communities have replaced trees based on the diameter of the tree and not just like a 3-for-1 kind of thing. And for example, in London, they go all the way up to 11 trees for like a mature tree that's doing a lot of work, sequestering carbon and those kinds of things in the community. But I also understand, this is urgent. We want to move this policy as quickly as possible. So I guess I wanted to open it up for discussion with council if we want to consider something a little more detailed that goes a little bit further and make sure that we are replacing, some of these really large mature trees with the appropriate amount of trees based on the work they do and not just the aesthetic value they provide.
Any other questions of the report before we get to that? Seeing none. Council, do you feel comfortable making a motion so we can have discussion?
Yeah, I can make a motion as long as somebody else writes the amendment. That is no problem. Moved by myself, Councillor Hughes, and seconded by Councillor Hallerow, that the Council of the Corporation of the Town of Ingersoll receive staff report A-003-023 as information, and that Council adopts the Plant More Trees report A-003-23, and further that Council directs staff to bring forward an amendment to the tree canopy policy to affect the goals in this report. Discussion.
I can lead that because I'll continue with what you said there, Deputy Mayor. I think staff, I think this is Ingersoll's goal, and I think we have a lot of partners out there that are willing to step up, especially if we do. I know that I'll speak not as the chair, but as the chair of Upper Thames River Conservation Authority and towards their goals as well. We have an environmental target of planting 1 million trees in a certain time frame. So I'm certain that there would be a partnership available there. I think that Oxford County owns property within the municipality as well, and they certainly have a goal as well of planting trees. We have a lot of great community partners. I think the most important thing we can do is get trees in the ground. I definitely understand where London and those are coming from. They're being much larger municipalities. They have, I think that we can take a small town approach on this one and do some really good stuff. And then, as staff has said, have looked for those ways of really maximizing those efforts. I'd like to start now, and then once we get something going, see how it's working, and then maybe come back and refine that. The UTRCA also puts out a report card every 5 years. And what was crazy about this one over the last 5 years was that what we were seeing was the maturing of trees, because they don't count them until they're mature. So it takes about 20 years for a tree to mature. And so now we're seeing the benefits of trees that were actually planted 20, 30, 40 years ago come to fruition. So I think that while it's best to plant a large tree, every tree that we do will have an impact 20, 30 years later, more and more. So the quicker we get going and getting trees in the ground, the better. And so I'm supportive of this, and I'm certainly supportive of having further conversation to try to get that, to get even more trees in the ground wherever we can. Councillor Bowman.
Thank you, Mr. Mayor. I respect your comments, Deputy Mayor. Yes, I agree that a larger tree would start to work more efficiently right away, but I do like the 3-for-1 deal, where we can get a developer to plant 3 trees for every one that they remove. And I have to echo what our mayor has said. Over time, I think we're accomplishing the same goal, only over a longer period. So the sustainability would be there. So I think I support it the way it is now. And as the mayor said, if we have to tweak it down the line, we can tweak it.
You made me think, because I wasn't even thinking about that, so thank you. I too would like to stay with where we're at, but I would like to compromise a little bit and say, can we bring this back in 2 years and see where we are at with this program and look at changing it up if we think that we're succeeding? And because I don't want us to become stale at this either. And I recognize what, Transition Less Waste brought forward as well. And they want us to be even more aggressive. And I appreciate that. You want us to, I think it was a conversation I had with our CAO. You want the Cadillac version, and we want to give you the Cadillac, but we want to start off with just what we can afford, which is not the Cadillac. And I think we're doing what we can to get this going, and I'm with the mayor and Councillor Bowman in let's get this going, but let's not lose sight of this, and in 2 years, let's revisit this and really make sure that we are moving forward and we're trying to reach that Cadillac that TTLW has put before our eyes as well. So, and that other municipalities have. I wish we were London. I wish we had the tax base that we could afford to do that, but we just, it's a lofty goal, and I think it can be something over the next 4 years that we can look at. So I say, can we put it on there? Yes, I can put it as a friendly amendment, or is it okay that staff recognize that and are hearing me on that?
I think it's always fair that we could always ask for a report later on how we're doing.
Okay.
And seeing how, I think it's important
really
actually
didn't
to be able to
wanna
have a measurable effect on how we're making through our programs and making sure that they're there. Mr. Graves, would you like to?
Yeah, and what I would commit to is that we would do some kind of a report at some point, whether it be a part of the budget cycle every year, where we would say how much have we accomplished and what have we accomplished. So I think we'd probably do that annually. And I do know that Transition Less Waste will hold me accountable to that. So we will be able to make sure that we bring that report forward. So I think that's a natural time when council can kind of look at it again and say, are we accomplishing the goals? And or if we're over successful, can we raise the bar I think it's great to consider a higher standard, and staff love when we bring forward a recommendation and council says, let's do more. So.
Thank you, through you, Mayor. Is it possible that we can take advantage of the fact that we now have some kind of developments coming and we can kind of zone the kind of trees so that we benefit both ways? We have some that are aesthetically pleasing in areas where they can't take maybe much of the bigger trees, and then in some areas where they can, then we actually kind of balance it out, kind of like a zoning plan, so that we can achieve both ways.
Mr. Graves.
So a part of the recommendation and part of the planning process will be that we will require developers, first of all, to replace 3-to-1 trees, but we will also be doing, sorry, Danielle, am I doing, okay, sorry. And we will also be requiring them, as they do their developments, to take a look at where they can save those existing trees. We already do that to some extent, and there are a significant number of areas where they are required to save some. There was some areas that were looked at on one of the most recent developments, a pretty large area, where they are retaining a large portion of the trees. So we'll be doing that as well, because that is their cheapest method of doing the trees, is not buying, cutting down as many trees. So that's the first step. And then if they can't meet that, then going on to, and one of the ways that they could accomplish it too is that some of the trees that they can plant can be, if they plant 1 tree per house that they build. So that can be one of the ways that they can accommodate some of their trees that they cut down. So they may be able to accommodate a bunch of those trees within their own subdivision before they have to give those trees over to us to plant in another location. So those would be the first 2 steps. Identifying areas where they can keep and save trees. Secondly, where they can plant new trees in their existing development. And then lastly, where they can give us trees to plant in our areas.
So I just wanted to circle back to say that I'm suggesting or discussing the tree replacement for developers, not on the tax base. So not suggesting that we would suggest that. But I want to underscore that this is a climate change action. And, I want to be thoughtful, but I also want to underscore that climate change will not wait 2 years for us to take further action. So, I can understand and I hear what everyone's saying, and it sounds like we're going to go with what has been presented, but I would, urge my fellow councilors, not to be so patient on revisiting this again, because we really are in a position where we have to make some changes and take climate change seriously, and planting more trees is one way that we have within our control to do that. So that will be my last comment on this topic.
Further discussion? All I'll say is that we can always do more, and we should do more. But I think we can have a made in Ingersoll approach with this. I think that this opens the door for a great amount of partnerships and working with collaboration with other groups to try to increase that. This would be Ingersoll's share, but I think there's a need out there and a want to be able to do more, and so this would be an offer for everybody out there who wants to help plant trees and make that happen, that Ingersoll wants to be a partner of that, and we can move forward and figure out where we can start putting some trees in the ground. Further discussion? All those in favor? Opposed? That is carried. Next, we will go down to the second special staff report, staff engagement, morale, attraction, and retention. Mr. Graves, please.
Thank you. This is a wide-ranging report that outlines a number of options to attract and retain more employees. As many different types of employers have begun to experience, it has become more challenging to gather candidates with the necessary skills and training for various roles within the municipality. We currently have a team of staff that are second to none. However, many of our employees are being actively recruited by other municipalities anxious to gain employees with skills and experience. The bulk of these options are to be completed by staff in upgrading some of our HR policies and processes. Some of these options will require further study and reporting back to council. For example, some of the recommendations of parking will be contingent on the comprehensive parking review to be undertaken later this year. So some items will come back as part of the 2024 budget process. Some of the options are for council to consider, such as option 4, sick days allotment, option 5, closing town hall between Christmas and New Year's, option 8, the condensed work week, option 15 being amendment to the council code of conduct in the council staff relations portion. Of course, staff are available for any questions, including our human resources coordinator, Monique Donmeyer, who wrote the majority of the report and is attending virtually while currently on leave.
Thank you. Is there any questions of the report? Seeing none. There is a lot to digest in the report. One option is for council to discuss, and we'll work this out tonight, or would someone like to, the other option is to make a deferral to consider the information. Councillor Hughes?
Yeah, I would like to make a motion to bring this back at the next meeting. There is quite a bit of information here to digest since we received the agenda back last Thursday morning, to go through it and then, do the proper research that we should do. There's a lot of good stuff in here. I agree with that. Definitely agree that we do have a staff that is second to none. And, we need to take care of them, but we also have to remember that we have to take care of our residents as well and their tax and the amount of tax that they pay. Some of this would not affect that, but some of it will. So I'd like to defer this to the next meeting.
Would you like it enough to make a motion?
I will make a motion to defer this to the April meeting. Send me a piece of paper.
I'll second that motion.
I'm my own worst enemy.
I'll second that motion.
Deputy Mayor.
So just a comment that just being mindful that Monique is here on her leave and has made time to be here tonight and has sat here all night waiting for us to come to this agenda item. So, whichever way the vote goes, I want to acknowledge that she didn't have to do that, but she did. So I'll put that out there. And then a question for staff, are there any offers of employment that you would maybe like to have some of these in place and discussed before April, that deferring might put you in a worse negotiating position?
We are in the process of recruiting for a new director of engineering, and we were asked by the recruiter if we have these policies, and I've been advised that this is currently something that is asked almost every time there's a recruitment these days. I don't believe we'll be at the point of offering a position by the time the next meeting comes, but it may be a factor in someone's decision in that process. But
Councillor Halleru.
Definitely trying to rush through read the report. It sounded very good, and there are very good reasons why we need to take a look at it. But again, because of the timing, I think it's best to get the best, results for those considerations so that we are doing it right, once and for all.
Councillor Van Koen-Bosens.
I hate to say this, but I'm with Deputy Mayor Wilson. I had a chance to read through it, and I appreciate Monique giving of her time. So I would rather us go ahead and discuss it, but I don't know where everybody else is at. So I'm going to be with Deputy Mayor in wanting us to not defer this.
Could I just have the motion put down? Any further discussion?
Oh, okay.
Certainly consider it of staff time, and I appreciate that very much. I also consider that I do want to make sure that everybody is in full agreement on what needs to be done and moving forward and the implications of that. So I guess I'll call the motion moved by Councillor Hughes, seconded by Councillor Halleru to defer staff report A-004-23 to April meeting of council. All those in favor? Opposed? That's carried. I apologize. Lindsay. Excellent. Moving on to number 3, committee mandate review. That is the clerk's department.
Thank you. So this report is intended to seek council's approval of the proposed mandates for Ingersoll's Safe Cycling Committee, as well as the Recreational Trails Advisory Committee. As council will recall, at the last regular meeting, a staff proposal to combine the two committees was turned down, and instead council directed staff to come back to the next regular meeting with updated mandates for each of those committees. So similar to council's other advisory committees, staff reviewed each mandate through the lens of the strategic plan and attempted to incorporate comments from committee members where possible. Staff are recommending that the adoption of the proposed staff are recommending adoption of the proposed mandates with the accompanying goals and objectives. However, with the understanding that each committee can and should update its goals with council approval as deemed necessary throughout the term, which would then be reflected in the committee's terms of reference. To achieve harmony between the two committees and to acknowledge some overlapping goals, each committee contains a goal of working with the other on matters related to active transportation, as we had discussed in the previous council meeting. With that, I'm happy to answer any questions that council may have.
Questions of the report? Seeing none. Councillor Hudson, I believe you have a motion, please.
Thank you. Moved by myself, seconded by Councillor Van Kooten-Bosson, that the Council of the Corporation of the Town of Ingersoll receive staff report C-009-23 as information, and that Council approve the continuation of the Ingersoll Recreation Trails and Safe Cycling Advisory Committees, and that the mandates for each committee as identified in this report and as recommended by staff be adopted for the 2022 to 2026 term of council.
Discussion. Councillor Van Kooten-Bosson.
I want to thank staff for bringing this back to us so quickly and putting those mandates for the two separate committees. I think it's very well laid out, and I'm excited that we will be able to get these two committees back up and running very quickly with this report coming forward. So thank you.
Further discussion? Seeing none. I'd like to move an amendment to the resolution, the Council of the Corporation of the Town of Ingersoll, to add, provide education and promotion of safe cycling, and that the committee advise council on the role of the cycling coordinator to the Safe Cycling Committee's mandate. Would anybody be willing to second that? Councillor? Can you read that again? To add, provide education and promotion of safe cycling, and that the committee advise council on the role of on the goals of the safe cycling coordinator. Goals. Councillor Hudson, I believe you saw your to second that. Perfect. And I'll just speak to that really quickly. One, it mirrors what the education portion and the promotion of the trails, and that allows them to do their their education, the family cycling day, that sort of thing, and work with the health unit to provide different sorts of helmets and such. And then that the committee was very instrumental in getting the safe cycling coordinator position and providing goals to be able to, for that member to be, would be very beneficial, I believe. Yep. Councillor Van Kooten-Bosson.
So it's just for the safe cycling that we're promoting the education? Because you said trails in there, so I'm...
Sorry, the trails already has it.
Sorry?
The trails mandate already has that.
Oh, okay, thank you. I'm just trying to make sure of where we were at, which one we were talking about. Thanks.
Further discussion on the amendment? Seeing none, all those in favor? Opposed? That is carried. And now to the amended motion. Is there any further discussion on the amended motion? Seeing none, all those in favor? Opposed? That is carried. Excellent. Moving along to patios on municipal property. That is our Economic Development Department.
So this report is to determine council's interest in making the patio program permanent rather than reviewing it annually. In the past, the AGCO offered temporary extensions of liquor licenses to patios. However, that's now ceased. We're proposing a few changes this year, including a one-time building permit, provided the patio doesn't change, and a $50 application fee for annual renewal and agreements. We'll also be moving this program to the clerk's department as they enter into the encroachment agreements annually with the businesses. Danielle and I are happy to answer any questions council may have.
Excellent. Any questions of the report? Seeing none, I will ask Councillor Van Kootenbossens for a motion, please.
Thank you, Mr. Mayor. Moved by myself, seconded by Deputy Mayor Wilson, that the Council of the Corporation of the Town of Ingersoll receive staff report ED-003-23 as information, and that Council adopts the guidelines and application form attached to this report on a permanent basis. And further, that commercial patios approved under this program be exempted from the provisions of the Town of Ingersoll's comprehensive zoning bylaw. And further, that all costs associated with the design, installation, and ultimate removal of the pedestrian walkway and patio facility be the sole responsibility of the business or establishment utilizing the temporary patio program. And further, that council approve a $50 administration fee to process and execute agreements and for any inspection-related requirements to be reflected in an amendment to the 2023 fees and charges bylaw if approved. And further, that council delegates to staff the authority to administer the patio program to be formalized via bylaw at the next regular meeting of council.
Thank you. Discussion. I'll just say thank you to staff. I want to thank the merchants as well as downtown that took advantage of this. It was a successful program, and I think it will continue to be. People really like being outside and being able to do that. I also want to thank staff for looking at just the one-time bylaw, the building permit fee. I think that's a very good step forward in making it affordable to not have to do that every year. And hopefully everybody will be able to partake in the businesses that choose to do that. It's always nice to sit outside and have a meal or beverage. So. Any further discussion? All those in favor? Opposed? That is carried. Moving down to Carroll Street reconstructions. Mr. Graves, would you like to take that one, please?
Council will recall that during its budget deliberations that considered the Carroll Street reconstruction project, council budgeted for the maximum amount of the project being sidewalks on both sides of the street. But council also asked staff to conduct an open house to receive feedback from the residents on the street about which option the public would like, being either option 2, sidewalk on both sides, or option 3, sidewalks only on the east side. Attached to this report, council will see the summary of those comments received from the public. Staff now ask for direction on which option council would like to proceed with.
Questions for staff? Seeing none. Deputy Mayor Wilson, do you feel that you have a decision to put forward a motion? We can have further discussion to try to do that. So I'll chime in first as to get things going. I was at the public meeting. I thought it had a pretty good turnout. There was a diverse group of different residents that came out, and unfortunately, there was no consensus reached. So, which happens, right? So, from my perspective, the thing that really concerns me is why I would be in favor of actually the sidewalks on both sides. People were not opposed to that. I know when we did the Princess Park, people were very opposed to having sidewalks on their side, so they were very vocal about that. So I felt like if we were going to hear, we would have heard that. Second, most importantly for me, was that we heard from residents that it's a one-way street, so garbage has to be put from the east side, has to be put on the west side. And so if we didn't have a sidewalk, that would be going on someone's lawn, which may not be the best scenario going forward. So I think since we've already budgeted for it and I didn't hear anything super opposed one way or the other, I would be in favor of option number 3. Any further discussion for direction? Councillor Van Kootenbossens.
So at this point in time, I'm going to ask a question of staff then. If we stay with 2 sidewalks, it doesn't make the street any wider. And right now, we have parking only on one side of the street. Is that correct?
Yes, I believe that is correct, yes.
Sorry, just to clarify, the street will be wider either way. It's 6 meters now, it's going to 7. And so if the sidewalk is put on, there will be about 8, because there's a boulevard there plus the sidewalk, the residents will lose about 8 to 12 inches
Off their front lawn.
off their front lawn. If there's no sidewalk, they'll gain about 4 feet.
Okay.
But there'll be a curb right there. Deputy Mayor, would you like to make a motion and we can discuss?
Moved by myself, seconded by Councillor Bowman?
Sure.
Okay. And that the Council of the Corporation of the Town of Ingersoll received staff report OP-005-23 as information, and that council directs staff to pursue option 2, 7 meters widening of the road complete with sidewalks on both sides of Carroll Street.
Discussion. So I misspoke. I did mean option number 2 when I said I supported option number 3. So I do support sidewalks on both sides. And it's crazy, one of those things of where you do consultation, you get 0 answer. But the great thing is, there were some good comments that came out of that. I think that'll be able to use as just more information. And I think it was important that everybody came out and saw what was going on. And there'll be another public consultation meeting when they choose the contractor and they can show how that's done. So people were getting their questions answered. We just didn't get ours answered. Councillor Hughes.
For clarification, what is the width of the new sidewalks that'll be going on?
I believe they're 5 feet, so they are AOD, the new width. 1.2 meters, I believe. Further discussion? I'll call the question. All those in favor? Opposed? That is carried. Excellent. We are now moving on to the budget. 2023 operating budget. I'll start with Mr. Grace.
I'd like to introduce our interim treasurer, Mike Legg. He's taking the place of Irina and helping to keep us on the straight and narrow while Irina's away. We're delighted to have Mike here. And Irina, if you're watching, we all miss you and we are thinking of you and your family daily. Maybe watching.
Thank you. I'm not going to walk council through the presentation again. You've seen it twice already. There's very little change from the February 16th meeting. We have 2 changes that happened at the February 16th meeting to the budget. We've added $130,000 to transfer to reserves for the MERC, and we added an additional $2,500 to the council meetings and conference budget. So that adds an extra $132,500 to the levy. What that results in is we go from 1.01% increase from the February 16th meeting. We now end up at a 1.8% increase. With that addition, we are still well below every other municipality in the county of Oxford. Impacts to the medium single-family home go from $20 from the February 16th meeting to about $36. I will attempt to answer any questions you have, but it is not my budget. It's Irina's budget and the rest of the department heads, but I will do my best if I have to.
Excellent. Councillor Halleru.
I'm sorry that, through you, Mayor, I wasn't here when we did the last meeting, but I wondered, is this also the budget that we see the 3,000 deposited for the diversity committee? Proposed for it? Like, was that an amendment done?
I will ask staff. The 3,000, the diversity committee, $3,000 is within this budget, correct?
Yes.
Yeah. Councillor Van-Koop-Bosens.
Mike, you just spoke and said that it would be a 1.8% increase?
Yes.
Is that correct?
It's rounded to it, like if you want to take it to 2 decimal places, it's 1.83%.
No, because sorry, I'm looking at slide 7, and it says 3.08%.
That is your levy increase, but given your growth of 1.25%, that is strictly assessment that's new and growth.
Okay.
The impact is the 1.8.
Okay. We've been dealing with a 3.08% increase, and so I'm like, oh my God, we just dropped that much. And so I would just want to make sure that we're all on the same page then,
And this is
because I wasn't, so.
This is the common way of budget it. When you budget, you have your gross impact, which is the 3.08 you're talking about, and then you net off whatever you've got in extra assessment from growth. So the actual impact to the taxpayers is the net of those two numbers.
Any further questions? Seeing none, I'll call on Councillor Bowman, please, for a motion.
Thank you, Mr. Mayor. Moved by myself, seconded by Councillor Hughes, that the Council of the Corporation of the Town of Ingersoll receive staff report T-007-23 as information, and that Council approve the 2023 operating budget with a property tax levy of $16,965,280,000, and that Council approve the required transfers to and from reserves and reserve funds as outlined in the Town of Ingersoll 2023 operating budget. And further, that a bylaw to establish the approximate tax rate to affect the 2023 budget approval be brought forward for Council consideration in May of 2023.
Thank you. Discussion. Seeing none, I will. Thank you, staff. Thank you, Irina. Thank you, Mike, for stepping in. Thank you, staff. What we saw in this budget process was a very fine-tuned machine getting tuned even further. I know it was more in the capital, but it happened here as well. Staff were actively thinking and actively participating in budgeting and really realizing what they wanted to accomplish throughout the year and what that would cost the residents of the town of Ingersoll. I think past policies were showing extreme dividends. Our high reserves and the current interest rate were offset lower growth rates, and be able to provide a budget, as our interim treasurer has said, is the lowest within the county. And I think that speaks highly of our staff and what they've accomplished and what we can do going forward because of the situation we're in, our asset management plan, our reserves policy, our low debt, and continued level of service to the residents of Ingersoll. And we're actually seeing more happen. So given the rate of inflation that we've seen, I think this is an extremely responsible budget. We're able to add to it. So I thank you to staff for giving those options to be able we could add to the budget and still be responsible. And so as the first budget of our term, I think we should be very, very happy with this going forward. And it leaves us a lot of room to work within the next year and gives us a lot of options. So further discussion? All those in favor? Opposed? That is carried. Staff can go to work now. Or what? Excellent. We will now go down to correspondence. The first portion of correspondence, I had to apologize to Patricia when she sent that in. It came just before the beginning of the meeting, last meeting. And so I did say, I promised Patricia that I would read that as requested. And so I'll do that before we have the motion. It read, to Ingersoll Council Representative and who else it may concern, I write this letter on behalf of myself as the Director of ISAN Ingersoll's Indigenous Solidarity and Awareness Network. I'm an active community member and local mixed heritage mother of 4 Métis daughters, 2 of which openly identify as 2SLGBTQIA+. I write today to implore Ingersoll Town Council to heed the motion to implement a local diversity committee as well as join the coalition of inclusive municipalities. My reasoning to support this opinion begins with the first commitment from the list of commitments put forth by the coalition of inclusive municipalities. Increase vigilance against systematic and individual racism and discrimination. Systematic racism is abundantly evident in the basic structures of our colonial institutions themselves. Individual racism is the result of systematic abuse, internalized and weaponized to impose ideologies of systematic racism and discrimination. I believe the route to a more inclusive local and beyond environment is through the implementation of a community sensitivity education programs geared towards specific age groups, i.e. school-age children, church groups, and community programs. To further support this, I look to the second point laid out in the commitments: monitor racism and discrimination in the community more broadly, as well as municipal actions taken to address racism and discrimination. A huge or face repercussions for speaking up. I truly believe that the implementation of local anonymous reporting program to fight racism and discrimination, along with racism and discrimination guidelines, resource to define, it would give the community a solid tool and foundation of understanding as to how to address racism and discrimination when they encounter it. A further barrier to an inclusive and safe environment for all people, including minorities and marginalized people, is a lack of understanding of the effects of racism and discrimination on the individuals, families of discriminated people. This lack of support and understanding further suppresses those most affected by this issue. This is supported by the third point raised in the commitment to inform and support individuals who experience racism and discrimination. Regarding the fourth point, support policing services in their effort to be exemplary institutions in combating racism and discrimination. I believe that we can refer back to point number 2 and the idea of the community resource guide outlining the definition examples of racism and discrimination, along with an anonymous reporting system, would help enforce and support all services in their efforts to be exemplary institutions in combating this issue inclusively. Regarding employment opportunities and equity in the workplace brought up by point 5, provide equal opportunities as a municipal employer, service provider, and contractor, and point 6, support measures to promote equity in the labor market. I truly believe that community education is the key to implementing systems that promote an inclusive and safe environment, as well as empowering all employees to understand and feel safe to report when they encounter and experience racism and/or discrimination of any kind. I also believe that reaching out to Indigenous-based local contractors and services should be a priority at the municipal level as an act of reconciliation and a true steps towards equity and equality. In order to support measures to challenge racism, discrimination, and promote equal opportunity in housing, we need to relook at what is socially acceptable and even legally acceptable as a family unit. In many cultures, it is the norm to have extended family reside within the same home and share space resources with each other. In order to support the challenges, these notions, we must challenge our own perspectives and allow larger family groupings to reside within housing, whether private, public, or geared to income, to help support familial dynamics of different cultures and to also help support the needs of the current housing and economic climates. Once again, in order to support the point, involve citizens by giving them a voice in any racism initiatives and decision-making. I am brought back to the point 2 and the idea of implementing a community resource defining racism, discrimination, equality, equity, and inclusion, along with an anonymous reporting system for all members of the community to use. I believe this would empower the people at all levels of society to actively fight racism and discrimination and create a naturally safe and inclusive environment for all citizens. Promote respect and understanding and appreciate the cultural diversity and the inclusion of Aboriginal and racialized communities into the cultural fabric of the municipality. Firstly, I would like to address that changing the language use, Aboriginal meaning not originally occurring currently, and instead of using Indigenous meaning naturally occurring. In this point, as a first step for correcting incorporating cultural understanding and respect into the fabric of the municipality, ensuring that there are safeguards in place for land and stewardship. Consultation of Indigenous elders and communities before developing or selling of land, and publicly recognizing the colonial aspects of society, acknowledging making the discovery of the ancestral history of this area a priority, are major positive steps that the municipality can make towards truly addressing this point and intention. Thank you. Miigwech, merci for taking this time to read and consider these points of view. I truly hope that Ingersoll Council will consider what I have said and why it is of paramount importance that they implement a local diversity committee as well as join coalition of inclusive municipalities. Best wishes, Patricia Marshall. So, yeah, I do apologize to Patricia again and for missing that just at the last minute. So the good thing was we didn't go forward with that committee. So Councillor Bowman, you have a motion to accept this correspondence.
Yes, I do, Mr. Mayor. Moved by myself, seconded by Councillor Hughes, that the Council of the Corporation of the Town of Ingersoll receive the correspondence received from the Ingersoll Indigenous Solidarity and Awareness Network regarding the implementation of a diversity committee as information.
Thank you, Mayor. Moved by myself, Councillor Hughes, seconded by Councillor Hallerow, that the Council of the Corporation of the Town of Ingersoll receive the update regarding the Safe and Well Oxford Steering Committee from Julie Middleton, Clerk of Southwest Oxford, as information.
Thank you. Discussion. Seeing none, all those in favor? Opposed? That is carried. Councillor Hallerow, you have a motion for the gas tax, please.
Yes, please. Through you, Mayor. Moved by myself, Councillor Hallerow, seconded by Councillor Hudson, that the Council of the Corporation of the Town of Ingersoll receive the correspondence from the MTO regarding the 2022 to 2023 gas tax program as information.
Discussion. All those in favor? Opposed? That is carried. And now will, Councillor Hudson, you have for the City of Woodstock graphic image delivery, please.
Yes, thank you. Moved by myself, seconded by Councillor Van Kooten-Bosson, that the Council of the Corporation of the Town of Ingersoll receive the correspondence from the City of Woodstock regarding their graphic image delivery by law as information.
Discussion. Deputy Mayor Wilson, please.
I'm not sure about anyone else, but I've received this stuff in unsolicited in my door more times than I care to talk about. And anecdotally, I was able to stop my kids from seeing it because someone posted on Your Voice Ingersoll, just so everyone knows, this might be in your door, take it out before your kids see it, because it is incredibly graphic and harmful to kids and really anyone who sees it. So I would, encourage council to consider an amendment that explores this type of bylaw in Ingersoll. So I'll move that amendment. That council requests a report providing review and comment on the City of Woodstock's graphic imagery bylaw 9576-23, adopted February 16th, 2023, which regulates the unsolicited delivery of graphic images to residents.
Yeah, that was moved by Deputy Mayor, and the amendment was seconded by Councillor Van Kooten-Bosson. Is there further discussion on that? We can definitely look into it. I guess is how effective are the bylaws, and are they enforceable? So I guess we'll find out. Which is, I guess as I'm getting older, I said this the other day. I'm going to turn 40 this week, and I think that it finally kicks home that censorship is a needed thing in our society. For some things, and because I do think that kids, especially nowadays, are being extremely exposed to different things that even our generation and others were definitely not, and it's so easy to be exposed to different things that could have a detrimental effect on them. So, yeah, I can support that for sure.
I just wanted to add one more comment. My additional concern is now it's more expensive to distribute that material in Woodstock, so there might be a sense to go to other places where you don't have to spend extra money because, in Woodstock now it has to be in an extra envelope and so on. So, enforceable, we'll find out, but I think, we have to at least consider it.
Councillor Van Kooten-Bosson?
I think that the fact that London has implemented it in their community and now Woodstock, we usually take a little bit of a, let's see what other communities do and let them pave the way a little bit. So I think that they have, and it might be easier for staff to be able to investigate and bring back that in that respect. And with a young child myself, I don't need to have that coming to my door either, and try to keep eyes out for that. So that's why I seconded the motion, and thank you, Deputy Mayor, for writing out that motion.
Excellent. And all those in favor of the amendment? Okay, that amendment opposed, that amendment's carried. Now going back to the original motion, the amended motion. Any discussion on that, on the amended motion? Seeing none, all those in favor? Opposed, that is carried. And that deals with correspondence. We will now go into the bylaws. Councillor Van Kootenbosses, can you take us into the committee of the whole, please?
Thank you, Mr. Mayor. Moved by myself, seconded by Deputy Mayor Wilson, that the mover have leave to introduce and go into committee of the whole on the following bylaws. 1, Police Services Board remuneration, bylaw 23-5250. 2, gas tax bylaw, bylaw 23-5251. 3, confirmation bylaw, March 6, 2023, bylaw 23-5252. Council and the Committee of the Whole, Mayor Petrie and the Chair. On motion, the bylaws are accepted as circulated, and that constitutes the first and second reading of the bylaws.
Discussion? All those in favor? Opposed? That is carried. We are now in the Committee of the Whole. Would anybody like to discuss any of the bylaws presented? Seeing none, I'll ask for Deputy Mayor Wilson to take us out of the Committee of the Whole, please.
Moved by myself, seconded by Councillor Bowman, that the committee do now rise out of the Committee of the Whole.
Discussion? All those in favor? Opposed? That is carried, luckily. Third reading, please, Councillor Bowman.
Okay, yes, Mr. Mayor, moved by myself, seconded by Councillor Hughes, that bylaws 23-5250 to 23-5252 be now read a third time, passed, signed, and sealed, and this constitutes the third reading of the bylaws.
All those in favor? Opposed? That is carried. We are now about to go into closed session. Councillor Hughes, please take us into closed session, please.
Moved by myself, Councillor Hughes, seconded by Councillor Helleroo, that the council do now go into closed meeting at 10:24 p.m. pursuant to Section 239, Bracket 2 of the Municipal Act 2001, as amended, to discuss the following matters. Closed session minutes, November 8, 2022. 2, Section 239.2, Bracket I, as proposed, or pending acquisition or disposition of land by the municipality or local board, and K, a position, plan, procedure, criteria, or instruction to be applied to negotiations carried on or to be carried on by or on behalf of the municipality or local board, Earth Board Special Shareholders Meeting.
Thank you. A discussion? All those in favor? Opposed? That is carried. Council will now go to the J.C. Herbert Room. I will ask staff, council and staff, if they're not needed, to either turn off cell phones as procedure by